My lord, I'm praying for posting of a writ petition, my lord, tomorrow, my lord, if it is not inconvenient for your worship, my lord.
What do you want?
My lord, I'm praying for posting of a new writ petition we have filed yesterday for tomorrow if it is not inconvenient, my lord.
Motion?
Motion, my lord. I'm obliged, my lord.
Wait, please, your lord. Lordship, in item number 7, Lordship. In item number 7, Lordship, the respondents have filed their affidavit yesterday, Lordship, and they've given us a copy only yesterday in the evening. Lordship, I'm praying for 1 week's time to obtain our instruction in the matter. It's a tender matter.
Stay?
Lordship,
Stay.
there is no stay order, Lordship.
It has been submitted by the learned counsel for the petition that he needs to obtain instructions of the matter. Consequently, it's the matter of weeks.
May I please, your lordship? Lordship, I beg to mention of WBC 223024 for listing of order. Your lordship, may kindly pick the matter of first week of August.
Yes.
First week of August
What do you want?
for order.
Order.
Yeah.
First week of August is only 1 day. Second week,
Second week.
it is a day.
I'm appearing in 23.
There has to be some survey report
That survey has been done, my lord. Report is coming
as
up.
per the last order.
What are these matters?
These are regarding construction of a
GMC market.
GMC market, my lord. That had been stalled, my lord, because some say they are ultimately it had, then they are Honorable directed there should be a meeting between the commissioner and the stakeholders. That was done. Later on, the survey was conducted by the chief engineer and likely to be.
Now things are going on in right path, Lordship.
Ultimately,
Discussion has been held in cordial manner. Minutes has been prepared and survey has to be done. That report has to be produced. I think
likely this report is coming up tomorrow, my lord, by the chief engineer. Chief engineer has done all the survey, my lord.
This is for non-paying. This is for what matter?
2 and 3, my lord.
The petitioner's grievance is that the respondents were not able to hand over the entire worksite to the petitioner and they handed over only a part of it.
that is in respect of item number 1, Lordship.
I am in. And what is 2 and 3? Here you get another, because of 3 matters, we have 2 GMC councils.
My friend is paying 5.
Why this is an old matter?
These are all matters.
What are these matters for?
Contact.
So, Mr. Chakraborty, what is your matter?
Item number 1, Lordship. One affidavit has been filed on behalf of the respondent number 2.
Finally come. We'll let us have that matter.
In item number 1, Lordship, one affidavit has been filed on behalf of the respondent number 2. I have required some time to file my reply, Lord.
Okay, what is your case?
Lordship, in this case, I am the contractor, Lordship. As per clause 21, the respondents have to, Lordship, hand over entire site to me, Lordship. But they could not, Lordship. In the meantime, 18 months was a completion period over. They handed over only 50% of the site, Lordship. I constructed my.
Now, what do you want?
Lordship, I filed representation to finalize the Lordship contract at that stage, Lordship. What I have done to the on the site handed over to me, and also.
Okay. So your case is that you want to means the contract has to come to an end.
Right.
Because the period is over, you have done some work
Right.
and they are not finalizing. That's what
They have also not paid my pending bills.
As well as your pending. That's all.
So
Now-
what happened, Lordship? I quoted my rate on the basis of schedule 2011-12, Lordship. So now the SPW schedule of rate was going on 2023-24, Lordship. So it is not possible for him to construct the building on the basis of that serial of. He requested to escalate the rate, Lordship, but they did not respond, Lordship.
So did you terminate the contract?
No, Lordship.
Now, what have you done? You see, if they are not in a position to hand over
Right.
and the period is over,
Right.
so what are you asking out here? You are asking that the period, after the period is over,
Lordship.
they have not extended the period of the contract.
Right.
So it has come to an end by a flux of time. So whatever work has been done by
Right.
you, should be said that it has been that portion you have done
Right.
your work,
Right.
and then they should finalize the bills.
Right.
That's your case.
Lordship, Lord.
Now the question is, isn't this a case coming with absolutely within the civil court? Why should this court direct them to do that? That is a contractual matter between you and them.
Lordship.
Whether you have done the work, whether they have not been able to do it, you want to seek for damages. Why these are not being done in the
Lordship, I
civil court?
request
Why are you
that
here?
I
Mr.
made
Nayak?
appeal, Lordship.
How is it possible that
Yes.
this court is exercising writ jurisdiction in these type of matters?
Yes, that is the maintainability part, Lord. And thus, so far as other part is concerned, if Lordship comes to page 108 of my affidavit. Lordship, it is admitted that one portion of the site has been handed over to him.
108 is an order passed by
This
the
honorable
spot.
court in 2169/2017, this is dated 6/4/2017. If Lordship comes to the third paragraph, Lord.
In view of the submission of AI in charge of Advocate General, the petitioner are given an interim protection from eviction. As the grievance of the petitioner against eviction has been taken care of, this court deems it appropriate the undertaking given by the learned senior counsel before the court submits that the basement contains flood water which will be disembarked and then to operate the market. In such an event, the municipal authority shall. But how is this order have any relevance to the present dispute?
So this is the other portion, Lordship, which we are unable to hand over to the petitioner for construction of the remaining portion of it.
It's okay. That's another aspect. We are not concerned with that. But what the petitioner is seeking out here is that the contract has come to an end by a flux of time, and therefore he is entitled to certain amount. Now, this court will have to carry out an exercise. What the petitioner wants is to find out as to whether the petitioner has done the work to the extent which you have handed over. What are the compulsions for which you could not hand over? And as to whether the petitioner is entitled to the amount for which he has done the work. Since all these things come within the ambit of the civil court,
Yes, Lord.
why should this court exercise 226 in this type of matter?
I absolutely agree.
Maybe you are there, but I would have understood that if you have taken a step for imposition of some penalty upon him, then obviously this court would have had the exercise of the jurisdiction to that effect. Look here, these are the circumstances you could not have done on the basis of the being arbitrary or unreasonable. But here is a case that he wants to put an end to the contract. He
Yes,
has
and
to
so
put an
far,
end to the
so far as
contract.
the
Yes,
last
so-
direction is concerned, Lordship, his only grievance at this stage, payment of the work that he has done, Lordship. That is.
So that
limited.
should go to the civil court.
Law.
How can this court decide as to whether those work, whether the final bills, those bills which have been prepared has been done in that manner or not?
Law.
We can't decide all these things.
Lordship, I made appeal that to them, Lordship, filed representation, Lord. Only Lordship.
No, representation, I understand, Mr. Counsel, your specific case is that only. That look here, they have given me 50% or 20% or 30% of the work site. I have done that portion of the work, and now they are not paying me my bills.
Lordship.
That's your case.
Lordship, his intention is not that, Lordship, he will not do the work, Lordship. Contact.
Counsel, I'm not saying that you don't have the intention of doing the work.
Ah.
You don't have the intention of not doing the work.
Lordship.
I'm saying you have. So for which you may be entitled to damage it. As regards the work for which he has not done. Now you see, as per section 48 of the Indian Contract Act, there is always a case of reciprocal promises. You have entered into an agreement with James
Right.
that you are going to construct this building in a total area of 1 bigha. This is for example.
Right.
they only give you 2 kathas of land. So you have done that portion of the work. So that remaining amount, but the contract could not be done because just for example, you could not do the entire contract, for which you may be entitled to certain damages, many other things, apart from what amount you have claimed. So these are aspects which have to be dealt with before the civil court. How is the repetition that you are doing all these things? Now the question is as to whether they have been able to hand over, how much they have handed over, as to whether you have worked at an amount. You only want a direction out there for consideration, which I'm telling you, this court does not like to pass an order of consideration business.
So I
Yes,
will
yes,
have
of
time to take instruction from my client.
No instruction, matter finishes. It's item number 1, it has to finish on the
No,
first
Lord.
day. Has to finish by
At least
10:45.
1 week time maybe can tell us. At least 1 week time maybe can tell.
Huh?
1 week time maybe
1 week time for what?
for taking
This
instruction.
court is taking up this matter for this bench for the next 3 months. You have no way out.
Right.
10:45 it has to end. Any argument you have to make for 5 minutes more.
Lordship, going to that aspect, Lordship. Kindly give me 1 week time, Lordship.
For what?
Next week, Lordship, Lordship. will take
Why?
up the-
We have already spent 10 minutes of your time.
Lordship.
Okay. Here they say paragraph number 4 of the affidavit. As such, the difficulties cited by the petitioner for not being able to execute the work properly is not acceptable at this stage, as the work site condition was visible and detectable to the petitioner even before allotment of the work. Therefore, once the contractor chooses to accept the work, that too after visit of the work site beforehand, he cannot hold the respondent at fault, as is the settled principle of law upheld by so and so. This type of case.
Lordship, and next, Lordship, in paragraph 5, Lordship, they admitted that verbal contract was that
The
site
site
will
was
be
a
handed
busy
over part by
marketplace.
part.
Difficulties were there for handing over the entire site at one go, which fact the petitioner was also aware of. Accordingly, the petitioner was assured that he will hand over the site part by part, depending upon the progress of the work. The contractor was asked to erect a superstructure over the executed files so that the remaining vendors can be accommodated in the balance area. You have not performed your work.
I did my job.
What do you want? This court should dismiss your petition or give you the liberty.
Lordship.
No
Lordship, at
case.
least today, Lordship, I may be allowed some time, Lordship, to take instruction, Lordship.
Time I have given you 5 minutes.
Lordship, 1 week time, next week, Lordship, in any day,
Next
Lordship.
week, no.
Or Friday, Lordship, Friday.
Yes, sir. Okay, so far as this issue is concerned to be adjudicated by the court below, Lord. This matter goes
Let
there.
claim all damages, everything go before the civil court.
That is not-
It is the
To
only
that
way
aspect
out.
only, to that aspect only, Lordship, I may be allowed time to up till Friday, Lordship,
For what?
for taking instruction from my client, Lordship,
For what?
for the civil court, Lordship.
Whether he goes or not, I'm not concerned. I'm going to pass the order that this, I'm not going to exercise writ. Now I'm giving you the option for filing a suit if you want so. And the period during which the petition has been pending shall be excluded while computing the period of limitation. That's all.
Right.
That is the best order you can get.
Right.
And if I ask you to pass an order, the best order as you are asking for, which you can ask for, is that I should direct them to consider. They will again come back with their affidavit stand. What is there?
Lordship, whatever, Lordship, in May 2016, Lordship, one bill more than 15 lakhs was submitted, Lordship. As per clause, they have to make survey, Lordship, within 14 days, Lordship. But they did not. They have not paid that bill amount, Lordship.
And why have you moved this court in 2020? COVID was also not there.
Lordship, as because, Lordship,
The problem arises is that the advice. You have given a wrong advice to
And because
approach this
contract
board.
was lordship, was going on lordship, that's why I did not come lordship. Contract was going on, there was no adverse order from the authority lordship. And they assured that they will pay the bill amount. but did
I think we should close it. By 10:50, the order should come. Urge Mr. So the learned counsel appearing on behalf of the petitioner. And Mr. Pinak, who appears on behalf
I
of
will be
the
taking
respondent
item number
numbers
1, but
1 to 4. So the petitioner herein has approached this court seeking a writ in the nature of mandamus, directing the respondents to finalize the contract of the petitioner and release the outstanding bills, amount, as well as securities, including performance security. The petitioner alternatively also prayed that the petitioner be allowed to complete the project by applying the PWD SOR 2013-14. The question as to whether this court should exercise its powers of judicial review in a matter of the present kind can be taken into can be decided on the basis of the materials available on record. It appears from the facts as pleaded in the, as it appears from the materials on record, that the respondent number 2 had issued an invitation for bid on 11/12/2014, thereby inviting bids from registered Class 1A APWD/CPWD building contractors for construction of a multi-storied marked building for Guwahati Municipal Corporation at Kotasil, Guwahati, civil works, sanitary and water supply, including electrical works. Under the award of the 4th Assam Finance Commission for 2012-13 for an estimated amount of rupees 189 lakhs. The completion period was 18 months as per the invitation for bid dated 11/12/2014. The petitioner participated in the said said bidding process and was awarded a contract at a price of rupees 2,11,61,200. And the petitioner was requested to furnish the performance guarantee plus additional security within 7 days. The materials on record further show that the petitioner executed a contract agreement with the respondent authorities and deposited the required performance security. The respondent number 2, thereupon, issued a notice to proceed with the work on 6/1/2015. It is the case of the petitioner that the petitioner, in terms with the notice to proceed with the work, could carry out certain works, taking into account that the site in question was not made available to the petitioner. It is the specific case of the petitioner that the petitioner, after completing 47 numbers of piling works out of 226 as per the drawing, requested the site engineer to clear the other parts of the site by removing the present structure of disputes so that he can start the remaining piling work. However, the respondents did not provide the site for which the petitioner represented on various occasions. It was also the case of the petitioner that only 30% of the site area was handed over to the petitioner. And as such, it was difficult on the part of the petitioner to complete the work within the completion period.
Later on, sir, Lordship,
It is also the case of the petitioner that subsequently, the area which was handed over was only 50%. And there was an assurance being given by the respondent authorities that the remaining area would be handed over. It is further apparent from the pleadings as well as the documents enclosed to the writ petition that there had been various correspondences between the petitioner and the respondent authorities for handing over the entire site. But the respondent authorities did not provide the entire site. In the meantime, the completion period was over. However, the contract was kept alive by the respondents. It is the case of the petitioner that the petitioner had quoted the rates for completion of the work on the basis of the relevant market, by taking into consideration the relevant the prevailing market prices. It became impossible it became impossible for the petitioner to continue with the work if there is no escalation to the price. The petitioner also offered to complete the work if there is a price escalation being granted in terms with PWD SOR 2013-14. However, the respondents failed to respond to such representation. It is under such circumstances the petitioner had approached this court that the contract be finalized and the outstanding amount to which the petitioner is entitled to for the work the petitioner have done be paid to the petitioner. And in the alternative, the petitioner sought for that the petitioner be permitted to complete the work by giving him due escalation in terms with the PWD SOR 2013-14. It is seen that the instant writ petition was filed on 13/12/3/2020. And this court issued notice on 9/6/2020. It seems, Mr. Counsel, all this while you had nothing to do. You did not do. Then one fine morning, when the COVID broke in, so with the COVID coming in, there was no work. So this person must have thought that let me now go into litigation. The period when you filed, the notice when it is issued. The record reveals that the respondent number 2 had filed an affidavit in opposition on 12th of June 2025. It is the specific stand so taken in by the respondent that the petitioner, prior to entering into the contract, prior to submission of the tender, like all other bidders, were given a due opportunity to inspect the site. And the petitioner well knew that the site in question was used for the running a market.
Paragraph 5.
Was used for running a market?
Yes, already a market is there.
Used for running.
Understanding was that 50% will be
No,
completed.
no, that I'll do it. Was used for running a market. Was being used as a market. It was further mentioned that the understanding between the petitioner as well as the respondents were that the respondents would provide certain areas would provide certain portion of the site so that the petitioner would be in a position to carry out the construction. And once that construction is being carried out, the person who are carrying out the vendor, the persons who are carrying out market activities in the said area would be accommodated in the constructed area.
And admittedly, 50% was already.
And in that and as such, 50% of the site area was handed over. It was further the case that the petitioner, in spite of knowing the said condition, insisted on being given the entire site area. It is also mentioned that the respondent authorities took various steps so that the petitioner could be provided with
Paragraph 5, Lordship, second subparagraph. However,
that I have already written. Huh?
Lord. So he was asked to erect the superstructure over the.
Provide the balanced portion of the land. However, on account of an order dated, what is the date?
This is 6/4/2017.
6/4?
2017.
17, passed in WPC number 2169/2017. The entire area could not be handed over to the petitioner, isn't it?
Yes. That was the submission by him.
Was- This court have duly heard the learned counsels in the backdrop of the above pleadings. This court have duly heard the learned counsels appearing on behalf of the petitioner, as well as the learned standing counsel of the GMC. The question as to whether there was any discussions between the petitioner as well as the respondent authorities that there would be part handing over of the site, semicolon. The question as to whether the site was handed over, whether 30% of the site or 50% of the site was handed over. Semicolon. The question as to whether the petitioner was in a position to raise construction on the 50% of the site so that the persons who were already occupying the remaining portion could be accommodated in the portion which is being constructed, which could have been constructed by the petitioner. Semicolon. The question as to whether the petitioner had made construction as per the drawings in respect to the 50% of the area as well as what amount the petitioner would be entitled to. Semicolon. The question as to what amount the petitioner would be entitled to for the work the petitioner had allegedly completed, as well as whether there was any breach of the terms of the contract by the petitioner or the respondent authorities. In the opinion of this court, comes within disputed questions of facts which requires an adjudication by an authority, by an adjudicatory authority. Disputed questions of fact to be adjudicated by a competent civil court. This court further observes that if there was any breach committed by the respondents, the petitioner would further be entitled for, the petitioner can very well claim for damages. In the opinion of therefore, in view of the above, it is the opinion of this court that the present case is not a fit case for exercising the writ jurisdiction. This court, and accordingly, this court is not, this court dismisses the instant writ petition on the ground and then dismisses the instant writ petition. Be that as it may, and before concluding, this court, however, observes that as the instant writ petition is being dismissed on the ground of the writ petition being not maintainable, the dismissal of the instant writ petition shall not prejudice the petitioner to approach the competent civil court seeking damages as well as compensation, seeking his dues as well as damages or compensation if so advised. This court further observes that the communication dated 27/1/2020 issued to the Commissioner, Guwahati Municipal Corporation, enclosed as Annexure 20 to the writ petition, shall be deemed to be a notice as required to be filed prior to filing of a suit. Further to that, the period from 12/3/2020 till date be excluded while computing the period of limitation, taking into account that the petitioner bona fidely have been litigating before this court.
One word maybe lordship include the writ for approach the civil court for seeking redressal for bill amount. Lordship here including securities word maybe lordship.
Yes, performance security. His claims,
Security
all I mentioned is all his amounts, no? Any amount will come, which will include his
Including
outstanding
security.
bills as well as other dues.
No, one issue your lordship has settled that so far as the contract is concerned, he is no longer interested with the contract construction lordship. He is only interested for the payment lordship.
He also made an alternative submission. Nah? I have not said anything.
But only
No, Mr. Nayak, I have not said anything. I only mentioned in my analysis that these are the questions which are disputed questions. As such, I am not entertaining. I gave him the liberty to move the civil court. I gave him the liberty to make all claims. And before filing a suit, you are required to issue a notice as
That
per
your
the
lordship
particular
is-
provision. This is being dispensed with by taking into account Exhibit 20,
Yes. that I-
section Annexure 20, and the period during which the instant petition was pending has been excluded. Nothing else I have given.
No, my concern is that if I want to carry with the construction lordship by engaging some other contractor, we should not create any hindrance. That is the only aspect, Lord.
You are at
He may be
liberty.
approached the authority.
The moment you do so, he's there.
He may be approached the
Henceforth-
authorities, Lord.
Let him file.
Because his
But as of now, if he says,
No.
are you willing to do the work?
Lordship, maybe lordship.
No,
That's why I
No, no, I'm asking you, are you willing to do the work?
For that purpose, I have to instruction, Lord.
No, not necessarily.
lordship may kindly see the
If
last.
he interested, he will approach the
Only-
authorities, Lordship.
Lordship will only see the last order wherein he has stated that my only claim is for the money, Lordship. No other, nothing
See,
else.
you see, as of now, I have not passed anything. Now, tomorrow, you go ahead to give it to another and let him come. He has not said, he wants it as per the 2013-14 SOR, which today also he is not going to do it because now new SOR must have come in.
Lordship, 23-24. 23-24 coming to.
As per his relief which he's seeking also has moved me. Don't worry, Mr. Naik, go ahead with the construction.
Oh, Lord.
Full blessings. Yes. Yes, number 2 and number 3. Yes, what is number 2?
Lordship, as per
Which
order
one
date,
is yours?
These are the persons who are
we are the shopkeepers.
shopkeepers.
We are the shopkeepers.
You are Potasil.
Same thing.
Same market,
Same
same market,
market.
same
The
market.
construction
No,
of-
no, understood. These two.
These two.
Horipondo Mondal
Yes.
They are all the
and
shopkeepers.
Potasil. Both are your petitions.
Lordship. No,
Now you-
in one red petition, my senior appears.
Okay.
Item
Now,
number,
which is yours?
item number 2.
Okay, let us see your.
Last two order, Lordship, kindly parents.
Now,
Same,
what is
same
your
prayer.
case?
We are seeking same prayer.
Okay, what is your case?
Our case is that the minutes of the meeting, that has to be honored. A meeting was held.
Minutes of the meeting, forget about the minutes. I'm
Yes.
asking you, what is your case?
We are not against construction. Let them construct, but we should not be evicted. We may be allowed to carry out. We are ready to brought down our shops to giving a living area. for
No.
which-
One thing I say. On one hand, because of you, the construction is not being done.
No, we are not against.
No,
that.
you,
That-
no,
that-
you, it is
that I
not the
have stated
question.
in paragraph 22, Lordship.
No, you are not against means you choose for, you enter into some agreement with them for the time being
Time.
and say that let him go somewhere and you are going to give them again allot spaces something. to them.
Because they are fighting because once the construction is done, someone will go in the top, first floor. The business will be hit.
All
They want
cannot
the
be
front
accommodated
floor,
in the front.
Just accommodate in the front, but that's the issue, my lord. They are stalling the entire process.
No,
Let the minutes and the survey report.
this
be
is
produced.
absolutely within the domain of the GMC. I think this is a fit case for dismissal, right?
Lordship, I am on,
Okay.
I am on a evidentiary value of the minutes.
Bench may help you. I am not going to do it. Yes, Mr. Das.
Lordship, kindly peruse the
I
evidence.
am not going to interfere because of you. These
sir, because of you.
2017 matters, the construction
Yes.
has not happened. I'm not concerned to that.
Lordship, kindly
You-
peruse one
No, no.
decision on the
Only
value of the
thing-
minutes,
Only thing is,
whether minutes need to
whoever
be
is
honored or not.
working properly, working or has some license has been granted,
Yes.
they shall be accommodated when the construction is done.
Yes.
And you can go ahead and evict these people.
And for the time being, we may be allowed to continue our business, Lordship. We are ready to evict
If it
certain
is
part.
possible with the
possible.
construction.
Yeah, without disturbing the construction.
Without disturbing the
Without disturbing the
construction, and that
construction.
is absolutely within the domain of the GMC.
Lordship, that's true. That's true, Lord.
What is there to keep all these things?
Lordship, that's all.
No. Out, Mr. Mr. Dasgupta, that day in that matter, na? What matter is that? Section 30, no. That one.
Tomorrow it is fixed, no?
Huh?
Tomorrow, probably.
No. The other one where Mr. Kothari was appearing. Your matter, you were there on the other side for some respondent. Workman was, was delayed
yes,
by
yes,
60
yes,
days
yes.
or 50 days in
Ah.
coming. I made some changes to that effect because in my opinion, when the question of reinstatement was not there, the labor court exceeded its jurisdiction. However, I say, without there being
At that point of time, when the award was passed, Lord, at that time, the reinstatement was possible. Because
no, reinstatement was neither your case in your application nor your case in the reference. So I said that the labor court exceeded its jurisdiction to that effect. However, the back wages given of 50% shall be construed as reasonable compensation for illegal termination. And as such, these 50% should not be effective. So I kept that judgment remains as it is, but only the manner I have changed.
so far 50% baggage is concerned,
You will get it. That will be the compensation. That is the measure of compensation. 50% back wages. That is what I have also passed.
Hmm.
I only said earlier that when he has already superannuated, the question of reinstatement does not arise because the question of reinstatement was never there before the labor court.
it will not affect me.
It won't affect you, but the conclusion, the manner in which the arrived at the conclusion is different.
We are concerned with the money only. When it is not affecting us.
Okay. Mr. Dasgupta, the learned counsel senior counsel appearing on behalf of the writ petitioner in WPC number 2968/2018, and Mr. B. Chakraborty, the learned counsel. Which one is yours?
Item number 2169. 2169 of
Mr. B.
2017.
Chakraborty, who appears on behalf of the petitioners in WPC number 2169/2017. Mr.
All the respondents,
Espora appears on behalf of the GMC.
GMC, all the respondents.
The case of the petitioner, both the writ petitions are taken up together, taking into account the similarity of the issues involved. The case of the petitioners herein is that they are carrying on the business as vendors in the
Lordship, with shopkeepers, allotted shop, Lordship, not vending area, Lordship.
as shopkeepers in the, what is that?
Patasil
In the
GMC market.
Patasil Bazaar.
GMC market.
Bazaar, na?
GMC market.
GMC market.
GMC market.
পৌর নিগম বাজার গুলো কয় কি?
কমিয়ে পৌর নিগম দিবে।
Since decades,
Since 1966, Lordship.
since decades. The grievance of the petitioner is that the GMC, the respondent GMC, the respondent corporation is taking steps for construction of a multi-storied building. And the diagram, in the area, multi-story building, in the area where the petitioners are carrying on the business. The petitioners apprehend that the respondent authorities while evicting the petitioners may not raise the construction or keep the construction half done, and thereby the petitioners would be deprived of their livelihood.
Because Lordship, the Ulubari market has been fully completed. Till date has not been handed over.
In that regard,
Almost 10 to 15 years, Lordship.
reference was made to in the pleadings to the Ganeshguri market,
That is also half done till date.
which
And I have the latest photograph, Lordship,
have not yet been
of
completed.
that area, Lordship.
Mr. Beach, the counsel is appearing on behalf of the petitioner. In addition to the pleadings, also submitted. That there is a market. There's a GMC market at Ulubari, where the construction have already been done, but there has been no allotment since many years. And the petitioner's apprehension, therefore, that in the circumstance, the petitioners are evicted and the construction is not raised, or after being raised, the construction is not made, or after being made, allotment is not given. The petitioner's right to livelihood would be affected, which is a facet of Article 21 of the Constitution. The learned counsels appearing on behalf of the petitioners further submit that they are
Not against construction.
not against the construction, but would require certain protections so that they can keep on carrying on their livelihood
In the remaining.
while the construction is being carried out.
In the remaining part.
Leave something for me. Yes. Mr. Espora, no, Gustav, it is seen that pursuant to the filing of the instant writ petition, affidavits have been filed. Have you filed affidavit?
If it is not.
Not filed out.
Mr. Espora, the learned counsel, appearing on behalf of the petitioner, a respondent of the corporation, submit. Hey, I got file to dispose of file. Yeah? Do you have the earlier file?
No, no.
Anybody? The first file, both the councils have also left. I don't have the file also. Yes, you are there. Give your petition copy. Yes. Mr. Espora, the learned counsel, appearing on behalf of the respondent corporation, submitted that though no affidavit has been filed, but the seriousness on the part of the Guwahati Municipal Corporation to have a multi-storied building cannot be doubted, taking into account that an invitation for bid for construction of a multi-story building was issued on 11/12/2014. And thereupon, a contract was entered into with the bidder. And thereupon, a contract was, the contract was entered into with the successful bidder, and a notice to proceed with the work was issued on 6/1/2015. The learned counsel submitted, for the respondent corporation submitted, that only part of the site could be handed over to the respondent, to the successful bidder, to the contractor. And then also the respondent corporation kept in mind the interest of the petitioners. Mr. Espora, learned counsel, further submitted that the construction of a multi-story building is the need of the hour. And any steps and
Lordship, in fact, first basement and first floor casting has been done.
need of the hour. And on account of certain order, on account of various orders passed in the instant proceedings, the said construction could not be carried out in the entirety. He further placed before this court a minutes of the meeting held on 25/2025 between the members of the Petitioners Association, between the petitioners and the respondent corporation, wherein It was what is the decision taken?
And basically, they want to see it all over the setback. So
Huh?
that cannot be done in as part of paragraph 2. And thereafter, in paragraph 4, my lord, survey will be done by the chief engineer. That has been already been done, my lord.
This very certain discussions have taken place as to how to resolve this situation. This board also. In the backdrop of the above submissions, in the backdrop of the pleadings, the contents of the writ petitions, as well as the submissions so made by the learned counsels appearing on behalf of the petitioner. The question which arises as to whether this court, whether any interference is required in the from this court in the facts and circumstances of the instant case. This court have duly taken note of the submissions made at the bar that in respect to the multi-storied building wherein construction was started pursuant to the contract awarded to the successful bidder, the basement and the first floor have already been completed.
Only casting is done. Side wall, those are
Huh?
not- side walls, etc.
No,
not
no,
been done. Only the
basement and the
casting,
first floor.
only the casting is done.
No, there has been casting of the floors insofar as the basement and the first floor. As per the submission of Mr. Esbora, the said building is how many stories?
I don't that exactly not bad. That walk out the window.
Going it and see. Ground floor, basement.
Mr. Counsel, you
But-
cannot go to the civil court, na? You have to go to arbitration.
There is a protocol.
Make it arbitration, na? Arbitration. You'll get more money in arbitration. There's a clause out there. Hey, about the arbitration, clause 21. Arbitration.
One of the diagram I provided, there are leaves. So it will be a bit more. G plus, it will be G plus.
At least G+3. No.
I think there is a leaf.
This drawing only a basement and first floor, but lift position.
there.
not
How many stories building?
That has not been written.
What?
No, their contract.
Moment there is lift is there, it will be, I think it will be G plus.
At least difference 3.
Lift is nobody is going to do a market lift.
Minus 3 will be done. Lordship, the minute at page 73 will make it clear basement, ground floor and first floor. For the time being, I think it is in phase 1.
There are phases, right?
NXRL page 73. The fourth subpara. As asked by the Commissioner, Aline Begum, Executive Engineer, Building Division, GMC, narrated the technical aspect of the construction of first phase of Patition Market Building. It is stated in the plan of first phase of construction of Patition Market Building, there are provision for basement, ground floor and first floor.
That is the basement, ground floor and first floor, not more than that.
In the first
First
phase.
phase.
In the
It
first
will be
phase.
Phase wise, first phase it will
So
be.
they are having 3 phases.
Page 73. This is the minute Lordship.
How many floors you have to construct? You have constructed till first floor, but how many floors you were supposed to construct?
To second floor, Lordship. Second floor.
So it will be basement,
Basement.
ground floor, first
Yeah.
floor and second floor.
Basement, first floor, second floor.
Okay, Mr. You just find it out and tell me, huh? How many floors is there? Because here the drawings must have been submitted to him.
The drawing is there. One of my friend has a drawing.
Show me that.
This one.
Like extra page. Okay, this is. এটা প্রথম ড্রয়িং, এটা ফার্স্ট ড্রয়িং, ওইটা সেকেন্ড ড্রয়িংটা এটা প্রথম ঠিক। It has been had, it is this one drawing,
This is only ground floor. Illegal last time. Answer. Full stop. The materials on record do not show how many floors are to be constructed. And in what manner? And it floors is to be constructed. However, this court from the submissions so made by the learned counsels for the party presumes, and a party assumes that there are further construction required to be carried out next. This court also cannot be, this court is of the opinion that when a construction, of the opinion that the construction of a multi-story market is not only beneficial for the respondent corporation, but it is also beneficial for the shopkeepers who are carrying on the business. in the said market, as they would be provided better amenities. It is further seen that since the last decade, on account of various litigations, on account of various objections and litigations, on account of various disputes and litigations, the construction of the building, multi-story building, had not progressed. While the above aspect is also of above aspect, though is of vital importance, this court cannot also turn a blind eye to the rights of the petitioners in the present proceeding to carry out their livelihood, which also requires to be balanced, which is a facet of Article 21 of the Constitution. Under such circumstances, there is a requirement that a balance has to be arrived at, whereby the construction of the building can progress and the right of the petitioners is also least affected. Another relevant factor which also comes to the mind of the court while dealing with this type of matter that delay in construction with a public project leads to escalation, leads to higher costs, which is at the cost of the public exchequer. Accordingly, this court therefore disposes of the writ petition with the following observations and directions. The respondent authorities are directed to complete the construction of the multi-story building, which has already started within a reasonable period. Mr. Bora, how much time?
Break is over, my God. That period of item number one, that one Allah form hai.
Huh?
Now new tender had to be issued. Fresh tender had to. It will take time, madam. Tender. Maybe some structural diagram maybe have to change. Consume some
How much? 1 year?
one. It will not take 1 year. There. Once it is over, then
Because the casting has been done, na?
now
In the entire year, casting has been, piling has been
not
done.
in the
Not
50%,
entirely.
50%.
Not
Some area, na?
50%, more than 60%, about 60%.
Huh?
60% of the area, Lordship.
Itu agot likhi dibo, huh? 60% of the area take ground to enforce.
The entire everything had to be rest of the part. New tender had to be issued. Now it had to be.
Within
being
15 months? Within 15 months? Because earlier you gave 18 months.
15 months. It,
And preferably within 15 months from the date of the instant judgment. Question. Number 2. The commissioner, GMC, is directed to the petitioners herein are directed not to interfere with the progress of construction. Footstep. Number 2.
Lordship, as per the minors of the first two meeting, where to supervise?
I know how
Market
to,
committee, Lordship.
I know how to tackle it. Huh? This code further directs the commissioner GMC to accommodate the petitioners temporarily in the area where the construction had been partly done. So that they can carry out their livelihood. It is observed that the petitioner may not be provided with the same area as the petitioners presently are occupying. But during this interim period, prior till the construction is not completed, this court hopes that the petitioner would accommodate themselves next. Next. This court further directs the commissioner GMC that immediately upon completion of the building, allotment may be made to the petitioner, to all the shopkeepers who are presently carrying on the business in the Fatasil GMC market, and thereby giving them first preference, subject to compliance with the terms and conditions. Next. This court is aware that there can be no directions be passed directing the respondent authorities to complete the construction within a particular period, but hopes and expects that the same shall be completed within the time mentioned herein above. Next. This court further grants the liberty to the petitioner to approach this court in the circumstance they are aggrieved that the completion of the multi-story building is the multi-story building is not completed within 15 months from the date of the instant judgment. Last, you have not been able to solve.
Deeply obliged. Hope so now everything will come to an end, Lordship.
Has the fancy weather come to an end?
No, fancy weather will never come to him. Mr. MJ Borua will come up with answers.
Very difficult.
Hard cases is my case, Milord. The Bazaar committee. Probably this case will be covered by your judgment. Lordship.
Same judgment, I'm passed one judgment only for everybody.
Common judgment.
Common judge.
Didn't I put your name first? Heard Mr.
No,
Ida.
that's no problem. The only thing is, Milord, there was a regulation adopted on the 3/7/2014.
To
that
the effect,
To the effect, Milord. The Bazaar committee shall give the list of the traders who are carrying the business. And the person concerned who are carrying the business, they will be allotted the business.
they will do it. Therefore, I said not those who are carrying on the business have been allotted.
No.
They will be given first preference.
Hmm.
The person who have been allotted earlier in the Fatasil Shop Bazaar would be given the first preference because the building may go up.
Yeah.
The area may come down, may not be accommodated with the same area. Earlier, they were having 200 square feet. They may have 150 square feet. So the area will be, we are making a bulk.
Setback has to be there.
So Bazaar committee will furnish the list of the traders who are carrying the business.
Who?
The Bazaar committee.
Who is the Bazaar committee?
So for the PDF 2968.
I passed that order. And next is division bench. What is this?
May please, Your Lordship. My Lord will recollect one of the two proceedings, one probate proceeding and the other a civil suit for partition. The civil suit for partition was stayed under section 10.
Civil code for partition.
Civil suit for partition was stayed under section 10 in view of pendency of a probate proceeding. Now, my Lord,
Why should I take up this matter?
my Lord had heard it.
So what? I hear every matter.
My
So
Lord,
that you may not have later on a quarrel that this judge don't hear. Though yesterday there was one lawyer who said that I don't hear. Anyway, so that is his assumption. So therefore I told it that whatever I have mentioned out here is not a hearing being made by me. Should I take it up?
the
Yes,
last
I will.
occasion your lordship had queried regarding, my lord, just two facets to it, my lord. Either whether section 10 would cover such a case viewed from the principle of res sub judice, and secondly, your lordship had indicated whether there was a scope for amalgamation of the two proceedings.
Amalgamation not possible because of the fact that the probate proceedings would be taken up by the
By a
district
district
judge,
judge.
and a person will be losing his right of appeal.
They've done that, my lord, in other cases.
Which case?
Lord, even in Supreme Court, they've done
They
it
have done a probate with a AR.
with a suit. And your lordship will also recollect the other matter of Balbir Singh Vasu, there also it was done. Because in any case, we just want the proceedings to go on instead of being.
Now, if I remember correctly, those persons who is seeking the probate,
Right.
a person who is getting a probate doesn't get a title over there.
Exactly. Which is why Kawarjit Singh Dhillon said it can both can continue.
So therefore, proceedings can very well continue, taking into account that he becomes only an executor.
And whether the
And more particularly in terms with section 211 and 213.
And additionally, our ground of challenge in the civil suit was not that we've also said that the will is not genuine, but over and above that, the testator did not really have the title to bequeath or the testamentary capacity.
Because the question of title
Title
cannot
cannot
be
be gone in.
decided in a civil, in a probate.
Yeah, right.
And that person will only, in view of 211, will be the legal
He'll
representative.
be the legal representative.
I passed the judgment,
Yes.
one pertaining to, what's the name?
Some,
Sethi.
Shalini Shetty.
That judgment. And that is following that FTP
FTP and
and
Binapani.
Binapani. So you are challenging the title of the owner
Owner. Actually, the
or the testator.
testator. Yes.
You are challenging the title of
Of
the
the
testator in the suit.
In the suit.
So irrespective of whether
The will
the
is,
probate is granted or not, it shall not affect
yes, that's
your
right.
suit.
Yes, yes.
What do you say, Mr. Sharma?
My lord, kindly to the plaintiff. And in the plaintiff, they have not only challenged that title of the testator, but also that the will was executed by him in some ill-maintained condition.
No, will aspect cannot be decided in a
And-
suit.
and
There
they have-
is a bar.
And they have even challenged they have even tried for cancellation of will also in the suit. They have tried for cancellation of will also.
No, if they ask for many, that doesn't mean that they have no right.
My lord.
Now, see, a decree passed declaring the right of the plaintiff over a scheduled area, pass a preliminary decree of so and so. If the plaintiff fails, partition and deliver possession of the shares by meter that the court may deliver so and so. Properties are incapable of their precept be issued, cancel the scheduled deal in accordance with law. Where you're pleading out here that he is not the owner?
Page 22. Now, what has happened here is the father owned 2 properties, the mother owned 1 property at Morigaon. Now, the mother has executed the will in respect of all 3, which according to us, the first 2 properties were of the father. So, if anybody has to leave behind a will, it has to be the father. And she can at best bequeath whatever her share is. So, that she having included all of it, we are saying at page 22, if your lordship. Page 17, para 2 is regarding the title, respective title of the father and the mother. And page 22, we've said the will of so and so.
No, the question doesn't, I'm not going to decide as to whether the will can
Exactly,
be
my lord.
adjudicated by the
That's
trial
the
court
court
or
will.
not. I'm only concerned out here is if there's a will, a probate will be granted. The probate is to be granted as regards the authenticity of the probate and whether as to that whether the person executed the will
Mhm.
in right senses. These are the 2 parameters on which a will is being looked into by the probate court, nothing more than that.
Right.
But the probate court cannot declare
Title.
the title. The title as to whether the property would have been put into the will or it belong exclusively to the husband is a domain which comes within the ordinary civil courts.
That is true. But they would have challenged that on that part only. That is different. But they have not challenged that part only. They have challenged the will also. My lord, in para 7, my lord.
If
In
the
para 7,
will is being challenged, does it make, if the will, just for example, the will is being challenged also,
my lord.
the court will look into it because that will cannot be challenged unless in the proceedings in the probate. The court will look into it. I think the ordinary civil courts will know. We have very good judges.
The evidence will be there.
Where is that? In Guwahati?
The evidence will be there.
The
my lord.
will probate proceedings are at Guwahati. The civil suit is at Morigaon.
Which court? Morigaon and
Guwahati.
One is in Guwahati.
One is in.
Another,
The question of why section 10? Section 10 is that there should not be any conflicting judgment.
my lord, again,
Here there is no question of conflicting
again, my
judgment.
lord, there will be conflict also, my lord. They have claimed entire schedule 1, 2, 3 property, entire property they are claiming. So if the schedule, Probate court says that the schedule 3 property entire belong to mother and mother get given it, is will given in will. So that property, they cannot get that property. And then also,
Now, I can put a rider out there to that effect. As regards the will,
uh,
it is before the probate court where you have to challenge. That I'll put it.
then another thing, that whatever judgment is there in probate, that will affect the partition suit. If probate says that yes, she has
Then we
rightly-
stay the probate.
My lord,
Should we stay the probate? As you say that the judgment in the probate suit will affect the partition suit.
my lord, probate, it will be, my lord, that is why our Supreme Court findings are that the probate proceedings will definitely affect the partition suit.
Why?
Because,
How?
my lord, whatever
No,
judgment,
let us assume the probate which you are seeking has been granted. What is the effect?
my lord, in that case,
Now, what is the effect of a probate being granted? Tell me.
probate granted, my lord. If
What
the-
is the effect? That this person concerned is recognized as the executor of the will
my lord,
of the testator, one, and the testator's will or wishes that the property should go to the beneficiary. That's what is going to come up in the probate.
my lord,
But if the testator does not have the authority, can the probate court decide that aspect? No. And more particular, and further to that, as regards the legality of the will, the legality as to whether it is doctored, which is one of the contentions made out there in the plaint,
Yes, that
that
doctor
cannot
will-
be looked into
By the civil.
by the civil court. Maybe they have mentioned, but that cannot be. I'll put a rider to that effect. I'll make an observation.
my lord, that is my lord. But the decision in probate proceeding will not, my lord, the decision will not affect the partition suit, my lord.
No,
The,
go on.
the rights they have claimed in partition, they are claiming 1/3 right. Whether that will not be affected in the judgment of probate proceeding. If the probate says that yes, she has rightly issued the will, then one thing will go, schedule 3 property will go.
Huh?
Schedule 3 property will go. They
Go.
have admitted that is her property. also.
That will have an impact
Yes.
as regards Schedule 3
That's
property,
right.
but not as regards Schedule 1 and 2.
As 1 and 2, my lord, whether whatever property, whether she has executed will, if that property belongs to her, then again there will be conflict, my lord. Then again there will be conflict.
How there will be a conflict, Mr. Sharma? I'm not understanding that.
Suppose, my lord, suppose,
Very
my
difficult to understand.
lord, suppose, my lord, suppose, my lord, along with mother, if along with mother, there are 3 shares. He is claiming 50-50. Along with mother, there are 3 shares. There will be reduced, it will be 1/3 share. 1/3 share will be there. So probate proceeding will have direct bearing upon that. That is why.
How?
That is why.
No, tell me, what is the best order you can get in a probate? That the district judge will say that the probate I'm granting in favor of that particular person.
Hmm.
That's all. And the impact or the effect of that order is what? That the property which have been the executor has wished, the testator has wished that this particular property should go to A or B. That wish has come true. That's all. But the title is not given. The title, if there's a challenge, let us take another example. If the mother gives a gift by way of a registered gift, these 3 properties, can he not challenge it? Because the moment the gift is registered and it is being accepted by the donee, it comes into effect immediately. So under such circumstances, can he not challenge it? He can.
Can be there.
We can
If the mother
challenge.
did not have
Let
right
us
on the
therefore
property.
assume this is what the probate court will do.
Yes.
The probate court will say that this will is okay. Property, mother have rightly, the wishes of the mother should be honored. It's just a stamp of authorization by the probate court. That's all.
Well,
Which is similar to a gift being made by the mother out here. And if the mother's thing can be challenged by way of a suit, why not the suit should continue? It makes no sense. But only one thing, he cannot challenge the will in the suit. This aspect, I'll put it as a rider.
will cannot be challenged in any manner.
No, will can only
Only
be
on
challenged
point whether
in the
mother
probate
is-
court.
Only whether the mother has right to execute the will with regard to particular property. That is
That
different.
can be taken in the suit.
Yes.
Whether the mother had the right in respect to the property can be done in the suit.
Yes.
But as to whether the will has been doctored
Doctor,
cannot be done in the suit. It has to be done only before that court.
as to whether the mother has been doctor or whether the mother has
Now
mental capacity.
Now,
Whether mental- mother has
in
mental
view of the
capacity.
recent judgment of the Supreme Court, a registered gift,
Hmm.
there is always a presumption in favor of a registered gift. So, in view of the recent judgment, take those help.
Yes,
Find it out.
presumption means that
Chalo,
one has to prove it.
let us, I've given a lot of hearing.
So, my lord,
Lot of
that
hearing.
may be included, but the bill cannot be challenged either for the going
Pass the order.
or on the ground.
Mr. Sharma, I'm passing the order. If I'm mistaken out there, I leave out that option. You just remind me. Let me pass out.
I just want
Heard
the
Mr.
the
B.
doctor and regarding that mental capacity also they cannot tell.
Huh?
Regarding
Oh.
mental capacity, that one.
All these things cannot be adjudicated.
Right.
It has to be done only in the probate proceeding.
Yes, ma'am.
I'll make clear.
If they would not have included it, we would not have paid for stay.
Mr. Sharma, do you want this court to reserve the judgment? Heard Mr. B.D. Deka, the learned counsel appearing on behalf of the petitioner. Mr. S.J. Sharma appears on behalf of the respondent numbers 1, 2, and 3. 1, 2, and 3. The petitioner herein has invoked the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution, challenging the order dated 27/2024, passed in title suit number 13/2022, whereby the learned court of the civil judge, senior division Morigaon, had stayed the said suit, being title suit number 13/2022, pending disposal of the probate proceedings, being
PTS 5 of 20.
Huh?
PTS 5 of 20.
where is that?
Page 70.
8,
70.
7,
70.
70. Pending disposal of the PTS 05/2022, pending before the court of the additional district judge number 2, Kamrup Metro at Guwahati. Gusto. The materials on record show that who had executed the will?
Joy Lakshmi Bora.
One Joylakshmi Bora, the mother of the petitioner as well as the respondents.
My lord, mother-in-law and grandmother.
Huh?
Mother-in-law and grandmother of the respondent.
Mother-in-law, there's only one petitioner.
Yes, that's the son. Petitioner's mother,
Petitioner's mother and who is the mother of the petitioner and
The grandmother of
the grandmother
respondent number 1 and 2.
of the respondent numbers 1 and 2 and the mother-in-law of the respondent number 3, isn't it?
Sorry, mother-in-law of respondent number 2 and grandmother of 1 and 3.
Orupjyoti Bora is who?
Orupjyoti Bora is the deceased son, my lord.
Okay.
1 and
And
3
sorry,
are
Ranjan Bora is who?
deceased son's son.
Son
Son
of
of
Joylashmi.
son. Yes.
Who is the mother of the respondent petitioner and the respondent number 3 and the mother-in-law
My lord,
Will be the answer.
grandson.
and grandson
Yes,
of the respondent number 2 and respondent number 1 respectively. Had executed a will which is registered as which had executed a will on 3/6/2019 and was registered bearing deed number 7218/19. This registered will dated 3/6/2019 by this will dated, where's the will?
This is not an next note. I have a copy.
By this will, comma, late Joylakshmi Bora bequeathed the schedule 1 schedule A1, A2 and A3 properties in favor of the respondents herein, isn't it?
Yes.
In favor of the petitioner also.
Huh?
In favor of petitioner also some properties are given.
It was divided from. It was divided.
All these properties
Yes.
were divided.
Yes.
Divided.
Had bequeathed the schedule A1, schedule A2 and schedule A3 amongst the petitioner and the respondents herein. The said will, who filed the probate proceedings?
Respondent number 1 and 3. Respondent number 1 and 3.
The respondent number 1 and 3 filed a probate proceedings before the court of the learned district judge, Kamrup Metro at Assam, which was registered and numbered as Miss Probate case number 36/2021. The said probate proceedings thereupon was endorsed to the court of the additional district and session judge number 2, Kamrup Metro at Guwahati for disposal. The petitioner appeared in the said proceeding and contested the said probate. On that ground, the said misprobate proceedings was converted into a suit and registered and numbered as PTS 05/2022, which is presently pending. Next. The petitioner herein also filed a suit before the court of the civil judge Morigao seeking declaration of the petitioner's rights in respect to the properties described in Schedule A1, Schedule A2, and Schedule A3. Insofar as the share of the petitioner is concerned, and further sought for partition. It is also pertinent to take note of that from the pleadings made in the plaint of title suit number 13/2022 filed by the petitioner, the will executed by the mother of the petitioner dated 3/6/2019 also was put to challenge on the ground that the said will was doctored at the instance of the respondent numbers 1 and 2 herein. It is also pertinent to mention that the respondent number 3 herein is the performer defendant in the said suit. A further perusal of the plaint reveals that it is the case of the petitioner that the Schedule A1 and Schedule A2 property belong to the father of the petitioner, whereas the Schedule A3 belong to the mother of the petitioner. It is therefore the specific case of the petitioner in the suit that the mother of the petitioner would not have bequeathed Schedule A1 and Schedule A2 property in favor of the respondent bequeathed the Schedule A1 and Schedule A2 property, save and except her limited share which she had pursuant to the death of her husband. It is further noticed that pursuant to filing of the suit, the defendants in the said suit had filed their written statement. In addition to that, the defendants number 1 and 2 also filed an application under section 10 under section 151 read with section 10 of the Code of Civil Procedure 1908 for short the CPC agote upor jodi anichu CPC for stay of the suit pending disposal of the probate proceedings. Objections there again were filed by the petitioner. The learned trial court, that is the court of the civil judge Morigao, by an order dated 27/2024, had allowed the application so filed by the respondent numbers 1 and 2 herein, thereby staying title suit number 13/2022 till the disposal of the probate proceedings, being PTS number
Fine.
so and so, till pending before the court of the additional district judge number 2, Kamrup Metro at Guwahati, It is under such circumstances the present proceedings. This court have duly heard the learned counsels appearing on behalf of the petitioner, as well as the learned counsel appearing on behalf of the respondents, and have given an anxious consideration to the respective submissions made to made. Full stop. The question which arises, no, full stop. No. The point for determination which arises is as to whether the learned trial court was justified in passing the order dated 27/2024, whereby title suit number 13/2022 was stayed in disposal of PTS number 5/2022. It's a well settled principle of law that in the probate proceedings, the court dealing with the probate proceedings do not decide the title of the properties bequeathed by the testator. The probate proceeding, the probate, the court dealing with the probate proceedings primarily decides on the question of authenticity of the will, and as to whether the testator had executed the will in sound, what is the term used? Sound and
Sound and disposing mind.
sound and
Disposing mind. Disposing mind.
have executed in sound disposition of mind.
And
There's a
disposing,
term used,
sound and disposing mind.
and disposing mind. On the other hand, it appears, as is noticed from the pleadings made in the plaint, that the Schedule A1 and Schedule A2 property belong to the father of the petitioner belong to the husband of the testator, testatrix, that is late Joylakshmi Dasne Bora. It is the opinion of this court that if the probate proceeding, if the probate court, if the court dealing with the probate proceedings cannot decide on the title of the testatrix insofar as the Schedule A1 and Schedule A2 land properties, and can only decide on the question as to whether the testatrix had executed the will in sound and disposing mind, the question of staying the suit pending disposal of the probate proceedings by the learned trial court appears to be an error in exercise of jurisdiction. Accordingly, this court therefore interferes with the order dated 27/2024 passed in title suit number 13/2022. Taking into account that both the parties are duly represented before this court, this court directs both the parties to appear before the learned trial court on 1st of September 2025 for further proceedings of title suit number 13/2022. Next. Before parting with the record, this court, however, finds it very pertinent to observe that it is also a well-settled principle of law that the authenticity of a will cannot be questioned by way of a suit. Filed in the ordinary civil courts. The said authenticity can be only decided by the probate court, and in the instant case, as the petitioner herein have contested the will, it would be decided by the court, that is the additional district judge number 2 so and so. No more of civil matters, huh? No.
Item 6.
Next 3 months.
Wait, please, Your Lordship.
Yes, Mr.
My lord, now for execution of the registered deed, my lord, when we apply, now impression is sought to be given that the village itself is not non-cadastral village. Whereas
Huh?
actually, my lord, the petitioner, he is operating a mahal, my lord, stone mahal. Now he has taken on lease a particular plot of land measuring 7 villa. Initially, when he started with the business, my lord, he has submitted not a registered deed, but a notarized deed. Now that period is over. Now for renewal, my lord, they say that we should come up with a registered sale deed, lease deed. And we applied. Now the circle officer says it cannot be given because it is a land is covered by non-cadastral village. Whereas on the earlier occasion, if your lordship kindly comes to page 22, this is a one in vernacular, my lord, page 22, capital B.
Yeah.
This is from this Dhoritri portal, land records computerized project, Jori Phua Gaon, case number so and so. Now kindly see, my lord, village, Rongdi reserve, Potta number 98, dag number
Village, town,
village Rongdi reserve, name of the village.
now prior to that, there are two
This
words.
is the original one, my lord. Now, if your lordship kindly comes to this communication, from where we can get this information, my lord, page 50. This is a communication by DFO to the district commissioner, my lord. With reference to the above cited subject, I have the honor to inform you that as per minutes of the Stone Crusher Permit Committee meeting held on 19/10/23, communicated by the chairman cum conservator of forest, North Assam Circle, Tezpur, by letter dated so and so. The permit committee had decided to allow renewal of permit up to 31/12/24 in favor of BB Construction, Stone Crusher, that is the petitioner, and there's another, my lord, Borua, we are not concerned. subject to production of registered lease deed of land and submission of up-to-date land revenue. Further, 2 numbers of prayer petition has been received from proprietor of both the stone crusher unit along with up-to-date land revenue received for the year 23-24, as also both proprietor of stone crusher unit stated that the concerned circle officer of Bihupuria Revenue Circle could not provide land details as the village of Rongde Reserve under Laluk Moja is non-cadastral village and cadastral survey has not been completed. So the proprietor of the stone crusher units are unable to submit registered lease deed of land at this moment. Therefore, I would like to request you.
No, I don't understand how is this possible means along with the date land revenue received for the year so and also the Iman
Yes,
that the concerned circle of Iman could not provide land detail.
as the
As
village so and
village
so.
of Rongadi and the Laluk is non.
Ah,
Why do you need the circle officer to provide land details?
my lord.
Why do you need the circle officer to provide land details?
No, my lord, end of the day, we have to, my lord, enter into a lease deed.
How many years?
No, no, sir, 30 years. There is no dispute on that count.
No, you have, why I'm
More-
saying
more-
is that it has
More
to
than
be.
11 months, my lord.
Huh?
More than 11 months.
Okay, now therefore, you are required to take permission.
Permission.
Now, have you applied for permission?
Yes.
And have it been rejected?
No, my lord, question is now, the point is now they say it can't be given because it is a non-cadastral.
Who
village.
says?
It is the circle officer.
Where is that? No, this is the different thing, but where is it mentioned
Circle officer.
that the circle officer has done that? Because this is not understandable what they have done.
Please, please. Yes, my lord, if your lordship kindly comes to the affidavit, my lord.
Hmm.
Please come to page 67, my lord. This is in our the affidavit in opposition, my lord, filed by the other side. With
No, why
refer-
do you require these when you already have that?
No, my lord, for renewal,
No, understood. You only need to execute the registered lease deed. The lessor is there, lessee is there.
Ah.
Have you sought for permission which is required under 21A?
we applied online. my lord. Yes, it is
Okay.
poetry portal.
Was it granted or not granted?
No, not granted. Now the remark is this.
No, that can't be. This
Yes,
is not
Mr.
here
At
regarding.
least you, with
landscape.
reference to this, I am to inform you that Rongde Reserve of so and
Show me
so
your
is
letter
the,
of 25/10/2023,
yes.
which is your letter.
25 তাৰিখত চিঠিখন আছে আমাৰ কথা। Yes, page 47, my lord. With reference to the subject cited above, it is to inform you that on 33/18.
Why are you asking that? You are not asking for that permission. Only see, as such, you are requested to provide the status of the land and guide us how to execute the deed.
Yes,
Why are you asking for that? Why don't you get your deed registered? Matter over.
no, my lord, if your lordship will kindly come to page 47, last 5 lines, my lord. Although we have applied for registered lease deed online in the year 22, however, the same has not been done yet, and hence we are facing difficulty in renewal of the stone crusher permit. On the last meeting of the stone crusher permit dated so and so, we were asked why we do not submit the registered lease deed and when we can submit the same.
But this is of 2022. If
Yes.
you have not got it, then you have to take the recourse to that aspect.
No, end
No,
of the
I
day,
mean,
my lord, revenue authority, if they do not cooperate, I don't think it will be possible, my lord.
No, so therefore your cause of action is regarding not granting the permission.
Yes, by the forest authority.
No, not
No,
by.
sorry, it's for the revenue authority.
Under 2012, if when you applied, if you have not got that, that is the main cause of action,
Yes.
not this cause of action. Because of the fact, because the thing is, whether it is categorically you have a Jamabandi.
Yes,
Now it is already there, maybe an
we are paying
NC,
tax.
maybe a
revenue.
non-cadastral land or whatever may be. If it is so, The patta number is given, the land is given and all
So
this.
therefore it can't be a non-cadastral.
Can be a non-cadastral, in even NK lands.
Ah.
Just for example, in Karguri.
Yes.
Karguri registration, everything was allowed.
Permitted.
Permissions have been granted. It is not understandable that it cannot be granted for a non-cadastral land. Because it is the duty of the state to survey as per the land review.
Not be completed by
Yes, yes.
stated in
No,
our.
no, madam, madam, that is not the question. No, madam, that is not the question because of the fact. The question of not being able to complete the survey cannot take away a person's right to get the land transferred by way of lease or sale. So therefore, the survey is required to be carried out as a part of for collection of revenue. That's all. The once you carry out the what NC means what? Non-cadastral. Non-cadastral means you have not classified till now or made it, put it in a particular map. So that with dark numbers and patta numbers, if it is not mentioned therein, the problem arises is how will you be able to collect the revenue? That's all. Now, this is a duty which is to be complied by you. For that, you cannot take somebody else, right?
On lease deed, huh? Sell it. It's the deed of sale.
Decided stated that because now it's all online, Malak, because survey has not been completed, and that's why that number and patta number will not be in the portal, Malak. So in that case, Malak,
I have
we can
seen, no,
request
madam,
that
I have seen many cases where if the survey is not completed, just for example, that day another matter was there before me.
Milord, page
Here the
73,
survey-
they have already done it, Milord.
Huh?
Page 73 in our affidavit in reply, same village, they have already registered a lease deed, Milord. Page 73. Page 73 of the reply, Milord. Area of 2 bigha, Dag number, Milord, property description, area of 2 bigha, Dag number 5 tater of village, Rongde Reserve.
No, but Mr. Chaudhary, therefore, your cause of action is nothing to do with that. You know the dark number, patta number.
Yes.
Yes.
Why you are not apply, once you apply out there, if they don't grant it, that is your cause of action to come before this court. Why the permission has not been granted?
No, Milord, we applied in 22 before even we
But that
knew.
is not your cause of, why you are asking for dark number, patta number and all these things? You
I'm
already-
asking for all that I'm asking, they should facilitate, Milord, an execution of lease deed.
Why?
Because now this stand taken by them is non-cadastral, therefore they cannot.
No, but the
Because if
question
Lordship
is-
clarifies that, we'll do that.
No, the
Yes.
question is you have to ask for that particular area.
Huh.
Tertiary, the stop operation of so and so.
Huh.
Mandamus recall and directing the area to stop operation.
Huh.
Your entire fight is against this and mandamus issued by area. In
Yes.
respect of particularly Niman.
No, kindly see, due to the
Is it
failure
valid?
on your submit necessary document for renewal of license for BB construction, the renewal could not be processed.
No, the question is, first you have to apply and you have the permission not being granted. That is your cause of action before this court.
Yes.
Otherwise, wait, what is there to get it registered? There's no problem. You have the dark number, you have the patta number, get it registered. Now the question, madam, I'm telling you, you are saying that non-cadastral, you have the map.
Hmm.
What has happened is that you have not put it up in the online.
It will happen.
That is the question.
Because of border dispute, among and because of the border dispute, Balak, between Assam and Arunachal Pradesh, but that survey has not been completed. So, my love, that's why my love, that number, patta number could not be given. So.
But how on earth you are having, how on earth you are having this Jamabandi for that? How is it possible?
My love, because probably they could not, my love, get the revenue receipt, my love. So if they approach that, because they have already filed the representation before the district commissioner, my love, and if my love direction is given to facilitate the petitioner regarding if anything can be done, because
Because
they
the
have
question of
earlier number.
the question of this court's direction that you make it cadastral, that is, if that is being done for all times to come, he would never get the lease. That I'm not going to do it. The question is, the main problem which the petitioner have made a mistake is not challenging the action on the part of them for not granting you them the permission. a permission is required under 21A. They should challenge that before this court. Once they challenge it, this court can pass an order why you have not granted and accordingly get the thing done. This is how it can happen, Mr. Chaudhary.
That I understand, but only thing is, my lord, they have made us the known the reason. Kindly see once again, my lord. Now, when the DFO writes to the district commissioner, he points out that. Now, I understand your lordship's perspective, my lord, but we are, my lord, like a shuttlecock, where do we go, my lord? We have approached everybody. Our way is to we apply under the authority portal, which we did. They say it cannot be done because the system is not showing that it is a cadastral village.
No, therefore, you challenge that. You challenge that permission not being granted. I can very well pass an order to the effect if the permission is not being granted to the effect.
In that case, my lord, I'll amend this writ petition, my lord.
Amend or file a fresh one.
We'll file a fresh petition.
Because if you amend it,
I'll file a fresh petition.
one day you will amend,
Yes,
one
yes,
day.
yes. We'll file a fresh
And
petition.
then I'll take that matter with this and pass direction.
Yes.
Madam Das is always there to help. This is because the question doesn't, there are many lands, even if it is a non-cadastral, you have to allow it. But madam, I also want to know one thing. Nowadays I'm being told in the execution or registration of the sale deed, you only have to mention the dark number, patta number and everything. And then you have a ready-made sale deed, I'm being told.
Yes.
Huh? How is it
Dangerous things are
possible?
going on, Milan.
How is it possible? If you are having a ready-made seal, there are many terms and conditions which a person may like to insert.
But in the name
There
of
might be a conditional sale. How do you take care of? Means, or is it in Assam? It is not permitted.
in the name of ease of doing business, lot many things are done which is not proper, Milan.
Now think about your lawyer colleagues also. There are somebody surviving on that basis, drafting sale deeds.
Malad, that centers are,
Huh?
they are doing probate. Otherwise, Malad, why? how
Your
can
chief
we-
minister should think about that.
Malad,
That is- don't means what will happen? These lawyer colleagues, they have there are a lot of lawyers who are surviving only on making sale deeds, the agreement for sales and lease deeds. Now you want only give me us the dark number, patta number. You have a ready-made sale deed. It comes out. How is it possible?
Just insert it.
Huh?
probably
Surviving.
not. Malad.
Then in that case, if you don't do anything, then all matters filed by the writ petitioners
For the
have to be admitted. Notice has to be issued. We don't dismiss it because otherwise, where will they survive?
Yes, Malad, because next of.
Somebody
they
has to
all-
survive.
Now all online, Malad.
Now, online you do everything. Everything,
very
madam, you do online everything. But allow them to survive. All writ petitions, all suits have to be allowed to continue. There should be more and more pendency. Otherwise, the lawyers can't survive.
Yes, Malad.
Mr. K.N. Chaudhary, Lalanis Senior Counsel, submits that to obtain instruction as to whether there will be a necessity to challenge the non-granting of permission in terms with Section 21A of the Registration Act 1908 as is applicable to the state of Assam. List the matter when.
Next month. Next Monday.
No, we'll have it on a particular date after 2 weeks. In the meantime, you file the writ petition and then I'll
Lordships can
check
have
that.
it on 13th, Milan.
Yes.
Sorry. 13th,
Let
Milan
me
is a
have it on
Wednesday.
13.
13th
This
is a Wednesday.
matter, I will tag that new writ petition so filed
Ah.
along with this
Yes.
and then get it done.
Yes.
Okay. on
Deeply.
13. You have nothing to say. এলোকৰ নাম কেইটা দি দিব।
In this case, I am appealing to the respondent. If lordship comes to the operative portion of the chapter, lordship at page 15.
Page
15. 15. no? Okay, the direction was issued to verify the claim of the petitioner in terms of considerably. And subsequent direction was that shall be released in favor of the petitioner forthwith thereafter.
What is the order of 1511? Oh, this Borolan.
Yes, my lord. And so far as my affidavit is concerned, lordship, if lordship comes to page 24, lordship. His claim has been verified, lordship.
Then what happened?
And he has been placed at serial number 30, last page, lordship, page 24.
23.
Yes, page 24.
30.
Serial number 30, lordship. It's the petition, I mean, the
He's entitled to 19 lakhs.
9.
There's, Mr. Naik, there seems to be some problem with this Tamsir Ali thing.
Yes.
Tamsir Ali, on one hand, if I understand correctly, direct that they will, modalities will be created by PWD, whereby they will keep a particular seriality as regards the claim year-wise.
Yep.
So if so and so. So the payment also has to be mentioned, has to be as per the seriality.
So in this case, lordship, we have cleared payment up to 29. He is next 30.
Oh.
It was made, I mean, the payments were cleared in the last financial year. And our span, we have taken that this financial year, he will be at serial number 1.
This financial year means starting from 2025-26.
In-
So then we can have it after some day.
My lord, assuming that is the correct, my lord, here kindly say they have not mentioned the date of submission of the bill in this affidavit, page number 24.
Page?
My name should be in page serial number 27. 24, my lord.
Serial number?
My name should be in serial number 27. Because they have placed here in serial number 30. My name is there.
Oh, yours is earlier.
Yes, my lord.
Anyways,
But they
don't
have
fight.
paid up to 29.
They are going to pay.
They are
Let's
going
take
to
an
pay.
update.
My
So
lord.
page 20, lordship, specific government is there, and it is then now the petitioner will be accommodated for payment in the current financial year, that is 25,
when?
26. 25, 26.
25-26, it has 3 months have gone by.
Yes, 3 months ago.
Then how long?
Generally, payment starts from the month of June, lord.
June, we are in July ending, August. When?
July is over.
Let's have it in the last part of August, 27th of August. Give us an update.
In the meantime, lordship, I understand.
And the other matter? There's one matter only, no?
One,
Or two matters?
Serial
Oh, one
number
matter.
8.
What is this IA business? I'm pleading.
There's no idea.
Okay.
That's
The
already
instant
disposed of.
the who's the heard Miss Eboro?
No, I think.
What is
already
your name?
disposed of. Eboro, my lord. Yes.
Eboro, the learned counsel appearing on behalf of the petitioner. Mr. Pinoy appears on behalf of the respondent number 1.
Both the responses.
Huh?
Now 2 has been implemented.
Respondent number 1 and 2.
1 and 2.
So the petitioner herein have have initiated the present contempt proceedings for non-compliance to the order dated 10/2/2022, passed in WPC number 788/2022, whereby there was a direction upon the respondents to carry out the verification in terms with the judgment of the full bench in the case of Tamsir Ali and others versus State of Assam. And if it is found that the petitioner is entitled to the said amount as claimed, the same shall be released in favor of the petitioner. The case of the petitioner is that in spite of the said judgment order passed by this court dated 10/2/2022, passed in WPC number 788 of 2022, having been served upon the respondent on 28/2/2022. The petitioner's case have not been taken into consideration as in the manner as directed by the learned by this court. It is seen that this court had issued notice And further to that, taking into account, had issued notice, also, it is further taken note of that during the pendency of the instant contempt proceedings, the respondent number one was to the respondent number one was transferred, and the new incumbent holding the post of the principal secretary to the BTC is the respondent number two. It is further seen that the respondent number two had filed an affidavit in opposition on 18/6/2025, wherein it has been mentioned that as per the verification carried out, it was found that the petitioner is entitled to an amount of rupees 19 lakhs.
18.
And the respondents have already cleared the bills insofar as the persons at serial number 1 to 29 of statements showing outstanding liability, annexure A, and the petitioner being at serial number 30, he would be at serial number 1 as per for the present financial year, that is 2025-26. Mr. P. Nayak further submitted that immediately upon receipt of the funds, the petitioner would be the first person who would be paid his dues as per the verification conducted. Full stop. Taking into account the above, list the matter on 27th of August 2025, on which date the counsel representing the respondent number 1 and 2 shall give an update as to whether the amount have been dispersed to the petitioner. Amount which have been found and verified to be payable to the petitioner have been disbursed to the petitioner. List according.
Look, this amount is on 18 lakhs only. That is not 19 lakhs. That may be typographical error. It should be 18 lakhs in the order.
That
itself
is the
reflected.
1 lakh, take it as interest.
That may. I will be very happy with that.
Don't go into the moment I say anything, then they again go to Mr. Naik, who then appears for finance and create the problem.
No, no.
You don't know when it
Naik.
goes to finance, it is you have taking go first.
How like
Yes, Ms. Teka.
Affidavit has been filed, Your Lordship, and I have taken.
None appears on behalf of the petitioner on call, leaves the matter of the 3 weeks.
10.
May it please your lordship.
Ah,
Lordship, this matter has become infractuous.
infractious.
Yes, Lord.
Miss,
As they
Here the amount has been, as per our instruction,
M
as they
as they appearing on behalf of the petitioner submits that the order dated
4700.
Man kon je auto ke peaceful loga na order dated 19/9/2022 passed in WPC number 4700/2020 have already been complied with. Mr. Asolia appears on behalf of the respondent, taking into account the above, the contempt proceedings stands dropped.
oblige.
11.
Yes, Mr. Kadir, why
My
you
lord,
not paying
at
you?
about 11:30 PM, an affidavit received from the respondent number 3, my lord. I think it is not on record.
Huh?
Today, an affidavit filed by respondent number 3, my lord. If it is on record, may I submit my?
It has been submitted that the respondent number 3 has filed an affidavit in opposition. However, the same is not on record, at least the matter of 2.
No, I'm appearing for respondent. I entered my appearance today. Here,
Respondent number?
3.
You have filed the affidavit.
We have filed the affidavit today.
My lord,
This is the matter of the 2 weeks.
my lord, I have a prayer, my lord, and a fixed date may be given, my lord.
Why?
2 years back, the order was passed, my lord.
Okay, list the matter on 29th of August 2025.
Very long time.
2 weeks? No.
No, 4 weeks.
Okay, on the 18th of August
Oblige.
2025.
Oblige.
The registry shall bring on record the affidavit filed by the respondent number 3 to Custom. The petitioner, if so advised, would be at liberty to file reply.
Oblige.
12.
Complied, not complied?
Till today not compliant. Not compliant.
Why not complied?
The proposal was rejected by finance department. So department is preparing a fresh proposal, my lord. We placed that on record last time. So my lord, 2-3 weeks may be given. We will get the status of the fresh proposal that is being prepared for this financial year.
Have you submitted the fresh proposal?
Fresh proposal has not been submitted. It is under
Then it
preparation.
means that you are not interested. Because last time also you made the same submission. Almost 2 months back.
Since last
You
1 year.
make the same submission, or were you on holidays?
The vacation was also there in between.
Vacation is only for court, not for those.
But there's a change in chief engineer also in between. So
Then
that is why my lord. After 2 weeks, I'll get my lord proper instruction.
it has been submitted by Mr. I. Bottakur appearing on behalf of the respondents. The respondents are taking steps for submitting a fresh proposal to the finance department. So it is seen that this very aspect was recorded by this court in the order dated 23/6/2025. So, more than 45 days have passed by. 45 days? More than a month have passed by. The respondent appeared to be, the respondent have not yet. It is strange and surprising to note that even after a period of after a period of a month, the respondents have not yet sent the proposal to the finance department. List the matter again on 11th of August 2025. Mr. I. Bottakur shall apprise as to whether the proposal have been sent to the finance department by the. Best.
The other day I was just referring to the affidavit in opposition that has been filed by the executive officer. Now here, if your lordship kindly sees at paragraph 7, page 110. Now to the issue raised by the petitioners as regards the non-notifying of the enhancement of taxes. Now they have relied upon a notice, a draft publication of notice, which they have annexed in their affidavit at page 119. If your lordship sees at page 119 is the notice. Now they have taken up the draft proposal of annual budget estimate for the board, and on the basis of which eventually the enhancement. Now, the last paragraph of page number 119, my lord. Every ratepayers shall within 7 days from the date of publication inspection during working hours and may within the date scheduled as above submit to the undersigned constructive suggestions connected with the budget estimate for the consideration. Now, just above this paragraph, your lordship will see one line of the penultimate paragraph. The copy of the budget estimate is hung up
in the office notice board. Now, this is the mode of circulation of this notice. For a municipal area, we have responded to this particular aspect in our affidavit in reply.
Mr. Counsel,
we have filed.
did you seek? This was circulated where, that particular
Within the office of the municipal board.
notice board, deputy commissioner? They were,
No, municipal board. Office of the municipal board is the place where it was hung up.
okay, then
Now, to this, my lord, we have responded to the paragraph number 7.
page 120 is what?
Page 128 is there, affidavit, my lord. Now, this is basically the offshoot of the subsequent developments which have taken place. Now, on the basis of this was forwarded because no objection kept coming within 7 days. Now, it was thereafter forwarded for approval of the state government. Eventually, they say that it has been approved and now this rate of tax.
Page, what is this at page 128?
128 is the proposed rates of this 128 is their notification for conversion of the board into corporation. So for that, the proposal that was published in the some gadget that has been annexed here with. Now, this is another aspect of the matter, my lord. What I am on to is in regard to the provisions under section 68 of the Municipal Act. That was our contention right at the very beginning in the writ petition itself. That the mannerism, the manner in which the decision has been taken by the executive officer, and your lordship will kindly appreciate that it is the executive officer who is taking all those decisions. It is not a board. The board was dissolved way back in the year 2020, in the month of March.
Now you have a board.
No, we don't have a board because the
Well,
election has not.
Now, Mr. Doctor, regarding how is the Silchar Municipal Corporation? Now it's a corporation.
Now it's a corporation.
How is the corporation function?
Now, my lord, because this notification as a lordship has seen at page 127.
Hmm.
That was challenged before this honorable court.
Hmm.
And it was stayed. And thereafter, my lord, the final decision was given on 2024.
Hmm.
My lord, the stay was lifted. Then my lord, we are now in the process of going for election and all that. So hopefully, my lord, in the month of October or November, there is a chance of election.
So now it's a corporation.
Now it's corporation.
Yeah, some municipal some municipal corporation. So you are on the question of publication.
In regard to enhancement of taxes on publication, our humble contention is the manner in which it was decided is not in accordance with the provisions laid down under the Act.
Where section?
Section 68 of the Assam Municipal Act 1956, my lord. I'm not on the 22 Act.
58.
68 of the Act of 1956. To start off with section 68 for a while, man.
Taxes.
Taxes.
Subject to the provisions of the tax rule may be.
I'm on that word of which due notice shall have been given, imposed within the limits of the municipality, the following taxes, fees and tolls, or any of them. Water tax is one of them. There are other taxes. Now, this notice that finds mention in another provision. If your lordship kindly comes to section 79D for a while, 79D. Now, this also includes water tax. Your lordship has seen section 79D, rate of tax, the second clause, water tax. The manner in which it is to be fixed, that is also there, subject to the
So
provision.
has the annual rental value increased?
No, that is one thing. And then your lordship kindly seeks section 79F. Determination of taxes. The rate of taxes determined in accordance with the provisions of this tax shall be published by the respective municipal board town committee by issuing a public notice within a period of 3 months from the date of coming into force of the Assam Municipal Amendment Act 2012. This determination shall remain valid for a period of 5 years. At the expiration of every 5 years, new determination of rate of taxes shall take place and shall be published in the same manner stipulated in this case.
Now, last increase happened when?
2022, from 75 to 125,
Is it-
during the tenureship of the executive officer. And now from straight away 125, 300. Reasons may be there, my lord. I am not going to explore all, I'm not going to venture into all those
But
aspects.
you are saying that you cannot do so if it is within 5 years.
Yes, that is also there. 2022 was the last time the rate was revised from 75 to 125. And now in 2025, which is not 5 years, again, it has gone up from 125 to 300 as well.
Have you raised this issue?
No, that issue I have not specifically raised. I am overall into enhancement.
You file an additional affidavit on this aspect. Because this is a very vital aspect, because if I pass an order on this basis, then he will say that I have not been given an opportunity.
Well,
And this is not a part of a pleading which this court has passed.
The lordship will find the rupees 300 was charged by the Sewage Board, my lord, in the same, the other area of the Silchar part.
No, I'm
300
saying,
per month.
no, only on the question. As per 79F.
Yes.
The rate of tax so fixed shall be for a period of 5 years. Now, in between, do you have the power to increase?
My lord, let them take up that pleading, we shall make it.
See, I tell you,
Because as such, your lordship will not find, nowhere they have stated on.
that's correct.
because
I-
this becomes a bit easier for
Well-
exercising my power. Because on the question of what is the quantum, it should have increased or different. But when it is said that it has to be 5 years, then it has to be 5 years unless there is an amendment. Because unless you see in the minimum wages act, the minimum wages are fixed for a particular
Anyway,
period
yes.
and it will be increased thereafter.
Well-
But there is a provision in minimum wages act that the government has the power to do it prior to that also. If that power is not given, I think there is 2-3 judgments on minimum wages act
My lord.
in respect
My-
to that. You have a look at it.
And my lord, my learned friend will have to address your lordship, whether it is a tax or fee.
Tax?
That is also important part. to it.
Tax
Whether
or fee?
it is a water tax or it is a fee.
Why?
Because we are not charging water tax, because water tax your lordship will find, your lordship will find 78D, my lord. Your lordship 79D. The Roman water tax subject to the provision of section 68 and 71 of the set at the rate of 2% of annual rental value other than the user's charge. Now.
So you mean to say that this is not a tax, it's a fee?
It's not a tax at all. Now, if we impose water tax at the rate of 2% annual rental value, it is a huge thing.
Let's see your imposition, how you have done.
My lord, that we shall let him file in.
No. We'll look into it.
My lord.
Where is your imposition that you have increased?
Yes, that your lordship will find. My actual. No, they are saying, my lord, it has been enhanced from 125 to 300. Then your lordship will kindly see at page 126. Annexure 6.
Yes.
Fees and user charges. 37,14,861 we have realized. Now this is user charges in terms of section 79D.
No, it's okay. I'm not on that. Where is the charge? He's questioning the increase. Where? You have questioned the increase. Where is the increase?
My lord, your lordship will kindly see at page 13, paragraph 7. That is the entire increase in the writ petition. Page 13, paragraph 7.
Page?
Page 13,
That is
paragraph
pleading.
7. That is my pleading.
No. Where they have mentioned that there is an enhancement.
No, that I have not been notified with that. We have come to know, your lordship kindly sees paragraph 14, the last part of the paragraph. We have come to know about this enhancement from a newspaper publication dated 25/6/2024 of the locality, which I have annexed.
Where is that?
That I have annexed. That is at page 1, annex 1, page 33. This is the newspaper publication. I have annexed the vernacular, the original, and I have given the translated copy.
Lord, surprisingly, in this case, all the taxpayers are paying the enhanced rate. They have no grievance at all. Now, the fee of the persons, my lord, they are top class litigant of that area. And for some other purpose, they have come up to highlight their position in order to.
No, Mr. Dutta, where is the increase?
Increase, my lord,
Here they say that there is some increase by way of tax.
from rupees 125 to rupees 300 as water tax. They are saying in their pleading at page 13, paragraph 7. my lord.
Now, your thing is that paragraph 13.
The paragraph 7 at page 13.
What is your reply? Let us.
At
110.
page 110, paragraph 7. my lord.
No, have you raised the issue that it is a fee, not a tax?
Yes, we are saying it's a fee.
Where is it?
My lord, your lordship kindly see at paragraph 7 of our affidavit at page 110. The statement made in paragraph 7 of the writ petition that municipal board without any notification or intimation has enhanced water tax or other tax is incorrect and the deponent denies the same. It is respectfully stated that respondent number 6, after going through detailed review of the existing collection and expenditure, decided to enhance the existing fees, tax.
So are you therefore saying that you are not specifically mentioning that there is no, it's a fee, but you are just trying to make it ambiguous, saying it to be tax or fee?
We are saying existing fees.
Where are you mentioning that we have increased only the fees, not the tax?
No, my lord, fees, as your lordship knows very well.
I know what is fees.
My lord.
You need a quid pro quo.
Yes.
There's no quarrel with that
Exactly.
proposition. But my question is, where is your pleading that this is enhancement is only a fee, not a tax?
We have, my lord, says existing fees, then again tax. That way, as your lordship is saying, very specifically, it is not.
Then you can raise up these type of issues.
My lord, then we have said that existing fees.
No, you have to say that yes, we have increased the fees, not the tax.
Well, I understand your lordship, my lord.
You cannot come up with this. This is it's a vague statement to the effect that you have been thought
Maybe
of
give it a
this.
chance.
Means are we therefore to say that as regards the tax which you have increased, whether the tax was increased earlier within these 3 years?
My lord, it was earlier it was 125 in the year 2021. And then now it has been enhanced up to 300 from 125.
So can you do so as per 79.5?
My lord, 79, my lord, that way it is not as my learned try to project that is only after 5 years, not correct position.
Okay, let's read 79.5 then.
Yes. (79F), your lordship will find in page 54. The rate of taxes determined in accordance with the provision of this act shall be published by the respective municipal court town committee by issuing a public notice within a period of 3 months from the date of coming into force for the Assam Municipal Amendment Act 2012. these determinations shall remain valid for a period of 5 years. At the expiration of very 5 years, new determination of rate of taxes shall take place and shall be published in the same manner as stipulated in this section. For the purpose of this
It
section,
says
the word-
publish means to publish one vernacular in English daily and one in English news daily, predominantly in circulation in the notified area. Where is that? You have increased?
My lord, that your lordship has seen in the notice we have served by hanging in our.
No, hanging is not. You have the publication, it has to be in terms with 79 Roman 2. It has been stated what is published means.
Well, that's there, but then the publication is not there to say that is a absolutely incorrect statement.
Are you saying that you have published? So how can you impose anything unless you have published?
My lord, that is your lordship will find in page 119 that the notice was given by hanging in the.
When the Act says that publication has to be in terms with 79 Roman 2, publish means to publish in one vernacular and in one English daily newspaper predominantly in circulation in the notified area of the municipality. So as of now, you have not published. How can you charge?
But then in the notice board, it has been hanged.
Doctor, I hope you understand what am I saying. That submission makes no sense.
No, I could get what your lordship. wants.
Then where is the publication? You don't need to file additional affidavit. I put a query to him in my order. Let him come up with that. Heard Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, as well as Mr. S. Dotto, the learned senior counsel, assisted by so-and-so, appearing on behalf of the Silchar Municipal Board. Which is now the Silchar Municipal Corporation. The petitioner herein, by way of the present petition, have sought for a direction that the Silchar Municipal Board be constituted by conducting the elections, and further have challenged the imposition, the increase in the tax, more particularly the water tax, which was earlier increased in the year 2022 to rupees 125 to rupees 300 in the year 2024. The learned counsel appearing on behalf of the petitioner submits that this aspect of the matter the petitioner could come only to learn from a newspaper reporting. He submitted that if there is an enhancement which can only be done in terms with Section 79F of the Assam Municipal Act 1956, there is a requirement of publication in the manner stipulated in Section 79 Roman 2 of the Act of 1956. The learned counsel appearing on behalf of the petitioner further drew out the attention of the court to Section 79 Roman 2 and submit that the word publish have been defined to mean to publish in one vernacular and in one English daily newspaper predominantly in circulation in the notified area of the municipality. The learned counsel submits that a perusal of Section 79F and the explanation attached thereto makes it very clear that this enhancement of the tax has to be published in terms with section 79, Roman 2. In addition to that, the learned counsel further submits that the Act of 1956 is silent, it categorically mandates, more particularly in section 79F, that the enhancement, that the rate of tax which have been fixed shall remain valid for a period of 5 years. And it is only upon expiration of this 5 years there can be a new determination of rate of tax, which has to be then published in the manner stipulated in section 79, Roman 2. He therefore submits that the manner in which the Silchar Municipal Board have enhanced the tax is contrary to the Act of 1956, for which there is a requirement that this court exercises the jurisdiction under Article 226 of the Constitution. Per contra, Mr. S. Dotto, the learned counsel appearing on behalf of the petitioner, senior counsel appearing on behalf of the Silchar Municipal Board, submits that a question arises as to whether there has been an increase in the water tax or the fees in connection with the supply of water. Inasmuch as it is only when it is a tax, section 79F would become applicable. This court have duly perused the affidavit in opposition filed by the respondent, Silchar Municipal Board. But from the said affidavit, it is not clear that the enhancement is only in respect to fees and not tax. The reference made to paragraph number 7 of the affidavit in opposition by the learned senior counsel does not stipulate that the enhancement to which the petitioners have challenged the actions of the Silchar Municipal Board is a fee and not a tax. So taking into account the above, this court is of the opinion that an opportunity should be granted to the Silchar Municipal Board to apprise this court as to whether the enhancement which have been sought to be done is a fee or a tax. First, it is relevant to observe that when it is a fee, there has to be a quid pro quo element. And as such, if it is a fee, the Silchar Municipal Board shall provide the details of the quid pro quo. In addition to that, this court further gives an opportunity to the Silchar Municipal Board to apprise this court by way of an affidavit as to whether, if it is a tax which have been enhanced, whether the same has been done in terms with section 79F of the Act of 1956, read with section 79 Roman 2 of the said Act. When
After 2 weeks.
this matter for further consideration on 19th of August 2025, the affidavit be filed by on or before 14th of August 2025.
August.
My lord, one prayer may I make?
Yes, please.
Lord, till 19th, can there be a protection in
No.
the interim that, my lord, why I say so? Because there are notices being issued for disconnection of water supply in case of the payment not being made at the enhanced rate. That is why. I leave it up to your lordship if it is.
You have left it up to me. I have left it
My
up.
lord, 19th.
Not
My
pass any.
instruction is the, almost 90% of the taxpayers are paying. They have no grievance at all. Your lordship has seen who are the petitioners here. What is their agenda? My lord, the people are very happy. I have the instruction that every collection.
But Mr. Doctor, I understand everything. As regards, it should be 125 or 300, I'm not going to touch it. If it is a question of anything else as regards how much, because this is absolutely within the wisdom of the executive, I have nothing.
Exactly.
But if you are to enhance, it has to be enhanced in terms with 79(5)(f). And if it is to be done, there has to be a publication. And if it is a publication, the publication has to be as per the act. I would not touch if it is made from 125 to 300, but it has to be applied prospectively after the notice. That is, I made it very clear. I may not, I would pass an order. If you have not done, giving you opportunity for a period of 3 months to do that. This is the order which I'm going proposing to pass. So better off, I think you come up with that. That it is
I
not a
obliged to
fee.
Your lordship, your lordship has given us chance to qualify. Now,
So you,
we
once
just-
you do it, if it is, and if you say it to be a fee, it becomes very difficult for you also to maintain it. Because you have to keep it on a different, the quid pro quo element
Yes.
is a very difficult thing. It's a very difficult aspect. But as regards tax, if it is so, okay, I'm not touching on, I'm making it clear because the matter will again come back to me. 125 to 300, I'm not touching it, but it will be only giving you an opportunity to make the publication within 3 months, and thereafter you apply. This is how
My
it.
lord, I'm obliged to that. My lord, only thing your lordship will see that how we are losing. My lord, our collection is.
Mr. Doctor, I also know when the money has come up from 90% have already paid to you. Therefore, there is no challenge. It is only this 10 of 7 petitioners who are here.
Right.
So they have paid or not, I'm not concerned. But once which has been paid to you, the question of refund to them does not arise. There is also many judgments. See Mafatlal,
Right.
9 judges. So the question of refund does not arise. So, but you have to apply prospectively.
No, that I could get.
So that is the order which I'll pass. If you come up with that affidavit to that effect.
Much obliged.
My lord,
Item
the
18
session
and
on
19, stay vacated.
19th of August
August.
at 2 p.m.
Yes, sir.
Obliged.
Taking into account the tribunal at 2 p.m. But we accept
My lord.
that Mr. D. Chakraborty wants it specific.
My lord.
That day I fixed the matter at 12:10.
My lord. My lord.
Taking into account that Mr. Chaudhary, K. N. Chaudhary is very busy. So I've given a time exactly at 12:10.
Obliged.
Much obliged.
18 and 19,
May it please your lordship. Lordship, I have got the copy of the broadsheet according to 17.1 that they wanted. It is actually it is an internal document which is not uploaded, but for the perusal of the court.
So one relief is allowed?
my lordship.
One relief is allowed? You wanted 17.1.
This is shit. Lordship, if I may submit a few things.
You'll submit first. Let me have a look.
Lordship.
Now the broadsheet is being given. Now what is your problem? How many are there? 6.
Your
Madam?
lordship, if I may explain what has happened.
Please
That,
explain.
lordship, initially there were 9 bidders. Lordship can see page 1.
We are concerned with only
Only 4.
one
So
contract.
if I
Madam, the contract pertains to experience for running management running for newly constructed eco-tourism project for tourist facilities at Dibru Soikpa.
Yes,
So that is the contract.
yes, sir.
Now, how many bidders were there?
Initially, there were 9 bidders, Your Lordship.
Okay, then
Page 1, 2, and 3. In the ninth bidder, Lordship, you will see it is just blank. It is because the bidder is called Arvind, which is also mentioned in the technical summary report. That is annexure Q in the document that is submitted by the petitioners. Annexure R, tender summary reports, annexure R.
where do I find that?
R. In the writ petition, page 92.
We have the luxury of having 2 writ petitions. Which one?
The second writ petition. Actually, Lordship, if I may submit about the first writ petition, it needs to be disposed of because the matter is infructuous as on date. If I may mention that the Lordship can also put a quietus to that writ petition.
Don't worry, I'm going to put the quietus to both today itself.
Oblige, Your Lordship.
Yes. Now
Oblige.
come to which one you are referring.
Your Lordship, if that page 92 annexure R, which is the writ petition.
You are referring to the second one.
This is the 5687.
Oh, 5-6.
5687. Okay.
What is this? Page 92.
Page 92, Your Lordship.
Yes, what is this? Arvind.
Arvind. Now this bidder Arvind actually did not submit the EMD, did not deposit the EMD and also did not deposit the money for the cost of the bid documents.
Okay.
That is why this bidder was not even admitted. So 9 goes out. So remaining is 8.
So we are concerned with 8.
8 now. Lordship, if Lordship sees.
And whom did you give it?
Finally, Lordship, in the financial bid when it's open, Padmini Resorts get it. But what happens is that Padmini, because of the stay by this honorable court, the tender could not be finalized.
Okay.
The process could not finalize.
Now what is the problem here?
So now, Your Lordship, the other, if you see, Your Lordship, if I have the indulgence of this court at page number 3, with respect to DD bidders, page number 3, towards the end it is mentioned. The note part, towards the end, note part, MSDD bidders, as per bid eligibility criteria, the bidder should have experience in running a registered hotel, guest house, resort, having restaurant and F&B service. But as per documents submitted by the bidder, it is found that the bidder have a catering business. Hence, the bidder is non-responsive. Then now 8 also goes.
Now we are among 7.
Now we are in 7. Now for 7, this is the evaluation of eligibility. The first criteria is experience in running a resort, hotel, guest house, resort with an F&B service. They need to have a restaurant with F&B service. So when this was, and the turnover has to be annually, it has to be 1 CR. It has to be above 1 CR. So Padmini Resorts eligible. MB Om, which is the petitioner, they are also eligible. Then we have Shanti Houseboat. They are also eligible. Thereafter, the next page, Lordship, Prismatic Hotels, they are eligible. So, but Anuj Enterprise Boat Safari is not eligible because it was not a houseboat. It was a boat safari. So they do not become eligible in this. So they are out. Now we are, and then again, Ujjwal Barua, they are not eligible because they do not have rooms, do not have keys. They do not have rooms. So that is why they were also.
They have room, but the rooms doesn't have keys. Okay.
The terminologies, Your Lordship. So, Lordship, finally, we are now down to 4.
1, 2, 3.
We are down to 4.
Yes.
Now, this 4 bidders become eligible. Again, also, there's the last page, Your Lordship, page 3. Again, Ranga Residencia, even they do not become eligible because their turnover is less than 1 CR per annually. So, finally, we are down to 4. Now, this 4. Now, page number 4, for the 4, we have to, this was the evaluation of the technical proposal. Now, the marks are given. Now, how the marking system is done, this marking system is also present in the bid document that is also signed by the petitioner. Now, Your Lordship, if Your Lordship sees that for Padmini, they have given 10 marks for the financial standing and the 1 crore, whether they have a 1 crore turnover, etc. They have, Padmini has got 10. the petitioner has also got 10. Then Shanti Houseboat also has got 10.
But how
And
many years of the
Experience.
financial criteria is required?
It is minimum, we need minimum basically 3 to 4 years. So we'll give 5 marks. So here in this cases, all the bidders were above 5 years. So that's why they all gets 15 marks each. Everyone gets equal marks. If Lordship can see.
No, Padmini had only 4.
No, 2000, no, your Lordship, it is, yes, from 2013 to 2022, Padmini was already running. So they have an experience of above, it's since 2013, and they submitted for the bid in 2022. So their resort, so they got the highest marks, with 15. Actually, everyone got the highest mark. Even in case of experience is concerned, Padmini got 15, Om got 15, Shanti got 15, and thereafter.
No.
Since we are not on affidavit.
Why did Padmini get 15 when it only submitted for 4 years?
It is not in consonance with page 47 of the tender bid.
How did Padmini get 15?
Yes, your Lordship.
When it had only given for 4 years.
For the turnover, Lordship.
It's turnover.
That is what was the eligible. That was the criteria. They have to submit only for the past 4 years.
4 years?
No.
Past 4 years.
No.
Then why did the others submit for 5 years?
Page 47 of the writ petition.
5 years.
Specifically clear. They require 5 years.
The eligibility was given for all the years, your Lordship. If your Lordship.
Yes, qualification.
Number 2.
Minimum turnover of rupees 1 crore for the last 5 years.
Last 5 years.
5 years.
Then why? This is for old one. Why is it
Lordship, I'll just
17,
read
18?
it because I think the minimum qualification they require for the last 5 years. Your Lordship, actually, I have the technical evaluation committee members here present here with me. If I may be allowed to call them.
No. First of all, why we have only 4 years?
That I'm not very confident about. So actually, no, in this one it is not, but otherwise the Padmini has submitted that amount. The document is there. It is just somehow did not get reflected here. But the number is there. It is 2 crores.
Then next.
5 years is there.
Okay,
Yeah,
next.
document Padmini submitted.
Okay, here you have given 15 marks. Now,
Yes.
Now the question is that petitioner has been given less than 60.
Lordship, what happened?
Isn't it your case?
They say so by the affidavit.
No.
Yes.
That is your case. And if you don't qualify, get 60, then you are out.
And so far as respondent number 5 and 6 are concerned.
I'm not
yes,
concerned.
yes.
Don't fight with others. First, your case
Yes,
is
60.
you have actually should get more than 60. Now let's see the next one. Now what happened?
The marks, the keys, with respect to the keys, Lordship. So next is the marks for the personals, the key personals. So key personal marks are, it is written in the column, your Lordship. So for Padmini did not have anyone who has a bachelor's degree, so only that person, so they got 0 in the first column. But the rest column, there are 4, 4, 3. For MB Home, there was Jimli Das, who was I think was a bachelor degree.
So your housekeeping service, you gave the others 3 marks or something, but Padmini did
They
not
didn't
get any.
submit anything for that. That is why the more marks was given to them.
So
That is
all
why
of
it
them,
is delayed.
all of them. So 3 people got around 8 plus 3, 11, and Padmini, the petitioner got 9.
Yes.
And he got 9. Other Padmini.
Yes.
Okay, then what happened?
Then the keys, the number of keys, Padmini gets 8, MB Om gets 8, gets similar, that same marks in respect to keys. What actually tilted the balance, your Lordship, is the presentation. If Lordship can see page number 6.
He gave only 8 marks.
That is, no, presentation he got only 8 marks because, your Lordship, as far as what I've been instructed, the presentation of Padmini was excellent And an important factor in case of Padmini was what weighed the scale on favor of Padmini is that Padmini, because they have to show how much they are planning to invest in the project. Padmini gave an investment of 2 CR. Padmini was willing to invest an amount of 2 CR in the project, and MBO was willing to invest an amount of 28 lakhs. So definitely Assam Tourism will look into this aspect that the project, which was already sanctioned by the government of India and it was already built under the Swadesh Darshan scheme, it had to be given to someone who would develop the project more, because the project is of development, management, and operation. Development is a key component of this entire tender. So Padmini was giving, so that is why Padmini gets 31, and also Padmini's presentation apparently was excellent compared to the rest. Even Prismatic was also good. Prismatic also came up, but in the financial bit, Prismatic lost out.
So, this presentation, this Prismatic got 63.
Yes, because Prismatic gave a higher amount.
Presentation 19. No, wait.
Yes.
Wait. Presentation 40 marks, Padmini got 31.
Yes.
Isn't it?
Yes. Prismatic got more.
Presentation,
Prismatic got, yes.
petitioner got 8 marks.
Yes.
Shanti got 11.
Yes.
And the other person got 19.
19, yes, your
19
lordship.
got-
Shanti got 19.
Okay. Then what happened? So this is it.
So, lordship, so basically why Prismatic got more is Prismatic had given 2 crores 10 lakhs as the
Let
investment.
us therefore see, we are not concerned with other one.
Yes.
This, how is this going to be, the presentation is to be evaluated. Let us do that as per the tender condition.
Yes.
You get the
yes, your
answer
lordship.
there?
Yes, your lordship.
Yes.
And lordship, we can also see that.
Because he has been given 8 marks or 9 marks.
Yes.
Very poor presentation. Let
Page
us see that.
50, evaluation criteria for presentation.
Investment to be made for the upgradation of the property. You gave 28 lakhs.
Now you not know about that breakup, what was given there.
No, you have to know
If
yourself.
they say 28 lakhs, I go by.
No, Mr. Banik, you know what you have given.
Precisely.
You
Why-
know, you know what
Of course,
you
my
have.
client would know, certainly would know.
You, when the client is not represented by himself and he is being
I take-
represented by his lawyer, I will
Lordship.
presume that you appear on behalf
Lordship,
of the lawyer.
lordship.
So you get 28 lakhs, they get 2. Safety precautions to be taken by the employees and guests and sanitation, they have given. Beautification, methodology, so and so. Now these are all subjective except A.
Lordship.
Then what is wrong?
One view of the thing is that if presentation I miss out on marks and I am 50, the matter would end, certainly.
Only on that ground
I have-
because you got 8 marks.
I got 8 marks.
And the others here. Now, therefore, the problem arises is the B to H are all subjective opinions of their. I can't help it. Only A is the
makes it
objective.
Vast difference of in 28
The
lakhs
vast
and-
difference. So can't help it out.
I understand. But one thing, if I may point out,
Hmm.
this documents which are coming in not in form of affidavit, not regardless of the matter, since this is the evaluation of eligibility, and they would submit these documents to show that turnover for 4 years was given and not for 5. That's how they evaluate it. They might or might not have documents in their thing. I'm not on that. But the evaluation was done on 4. And on 4, it ought to have been rejected outrightly. That was not done. Today they say, no, someone submitted, but we have not evaluated.
But then Prismatic gets it.
Prismatic would not get it. I'm coming to
No,
that.
still
Prismatic would not get it. I'm coming to that. So far as I am concerned, it's only 28 lakhs crores on A. I may lose out. I may not have a word on that. But so far as this is concerned, they evaluated on 4. They could not have allowed on 4. That's all. So far as Prismatic is concerned, I would refer to their affidavit where we have taken a stand that they have not shown their experience part. And in their affidavit at page 170, they have said 171 for prismatic.
Ah.
171.
Yes.
Out corresponding to my page 27. The subsequent part, if I may read, Miller.
Yes, which paragraph?
13. 13.
1-3.
13. 171.
Ah.
The first part I may skip, but I'll still read that part. That the statements made in the writ petition by the paragraph 23 of the writ petition are categorically denied in entirety, and the deponent further states that the bid of the respondent number 6 is not liable to reject it. As regards the statements made in paragraph 23A, it is humbly stated that the respondent number 6 had submitted a certificate issued by the chartered accountant to the effect that the respondent number 6 is engaged in the business of running hotel, restaurant, and bar for 5 years, starting from financial year 16-17 to 2021. As such, the mandate of clause 3.2 has been duly met by the respondent number 6, and
Who is
consequently,
6?
prismatic.
Which 6? Respond number 6.
6 is
Padmini.
Prismatic.
Prismatic.
The other one. The
prismatic, the other one.
Other one.
But many would go for 4. I'm on the last one now. And consequently, the bid cannot be rejected. Now, as regards the statements made by the writ petitioner in paragraph 23B, that yearly occupancy 30% as required under clause 3.2 has not been submitted by the respondent number 6. It is humbly stated that the respondent number 6, while submitting bid documents, had categorically shown that Aroma Residency, unit of respondent number 6, had a property of 36 keys with yearly occupancy of more than 75%. My lordships, the requirement is of the bidder to have, not of a sister or other concerned to have. They do not deal with that part. Page 42.
No, here experience has been given for Aroma Residency only, prismatic.
Absolutely. It's not prismatic. It's a concern of prismatic.
Why you are saying that it is a concern of, it's a company? Prismatic is a company.
Yes, you know.
It's a unit of respondent number 6.
The name of the hotel is on
Tomorrow, Mr. Banik may have 4 properties out there. So it becomes one of the properties. Then what does it matter?
We had taken the stand that they not submitted.
Anyway, now let us come to the financial bid of the respondent numbers. Who are these? 5 and 6.
Mine was not
Well, 5 and 6. Financial bid, we don't have the documents here, but financial bid, it was won by finally because the rental that is given by that is because the bid reserve price was 1,30,000, your lordship.
Let us see that the minimum qualification, what is required. Whether did you submit? Did you make an allegation as regards non-compliance to 2? Turnover.
3. I mean 5. Respondent number 5. Padmini.
Padmini.
I say they evaluated by 4 years. They cannot now say there is a 5th year document with them.
Now, is it required?
Yes.
5 years.
Yes, required 5 years.
Then, madam, how is it possible that Padmini will be qualified when 5 years is not there?
5 years are there, your lordship. It is in the documents. If your lordship requires, I can submit the entire document that is submitted.
Give me the
by
document.
Padmini.
Where is the document? You have to produce the records only. Didn't that pass the order that
Because
produce the
actually
records?
it was not.
Yes,
Lordship says that they have challenged this tender process under 5 counts. And if I can address all those 5 counts. Did you see the page? Page that has one. Last page, huh?
Oh, they have given.
Yes, your lordship. This is their entire bid document, your lordship.
16, 17, 17, 18, 18, 19, 19, 20, 20, 21.
That is why 21, 22 was planned.
Well, you seem to have made some mistake.
Well, writing the turnover, your lordship, from 16, 17, they were showing
21, 22. Other people, why 21, 22 has been taken and now tell me, Padmini, the problem arises there. You see what has happened? They have given the financial year from 2016, 17.
16, 17.
This is to be given as per what? 2017, 18.
17, 18.
They did not give for 2021, 22.
So they go.
Then it should have been rejected.
Rejected.
Who is paying for Padmini? Yes, come. How is it possible? You did not submit for 2021-22.
That instruction I don't have because it was not a pleaded case there, my lord.
Huh?
That instruction I don't have right now because it was not a pleaded case there, my lord.
Not their case.
It's
So
not,
how
it's
could
not
we
in the
have
pleading,
known?
my lord. Only the allegation is in paragraph 22, lordship will see that not alleged regarding this, we have not submitted document, my lord, financial document. That instruction right now I don't have, my lord.
No, madam, this is your document, see.
Yes, sir.
And kindly come to page 47. That is why you don't see 1 year. Because what Padmini made the mistake
Of submitting one document earlier, from one financial year earlier.
earlier. They should have done from 17-18, they gave it from 16-17.
17 onwards.
And 16-17 onwards, they have given from, therefore they missed out on 2021-22. And the tender was issued. Let us see this. This is the only a format. Where is the evaluation, where is the terms of the contract? Terms for the submission, online bid is so and so. What are the documents to be included? Amendment, bid security, performance, evaluation of the bid, Here you see, the tender was issued 21. Tender was issued on 31/5/2022 or 23/5/2022. And minimum average turnover of 1 crore for the last 5 years. Financial report for the last 5 years, balance sheet, profit and loss accounts, auditor's report in case of companies, corporation, etc. Then in that regard, kindly come to page 42, clause 3, Roman 5. This is the question of eligibility.
Prismatic goes on same count also. Prismatic also fails on the same count.
How?
Page 2 of whatever document madam has submitted, my lord.
Yes.
This document, my friend who has submitted, my lord. Page 2. Page 2 and page 7.
Yes, why?
21, 22 not given. Prismatic, the middle one.
No, it has not been given.
Not given, and page 7, my lord.
Prismatic also has not given
Not
that.
given. So it's only us who have given.
Then?
Your
And
lordship,
page 7, my lord.
it is better if we ask the technical
it's
evaluation
not-
team, they are here. I can
Please
tell them,
ask them.
they can,
Ask them to come.
yes. And also there was also a part, it was the tender was floated in June, your lordship. So there is a possibility that balance sheet had not come for 21 because it was 21-20
I'm not concerned with the balance sheet. I'm concerned with the year.
turnover.
The tender was quoted on 23/5/2022, meaning thereby when it is mentioned as the last 5 years, will have to be ending on 31st of March 2022.
22, but the balance sheet will come later.
I'm not concerned with the balance sheet. Balance sheet is not
And the
required.
turnover will come to know only later, your lordship.
Financial
Only when the
report for the
auditor,
last
because
5
one,
years.
they are 1 CR above. They are a company that is getting 1 CR above. So they're auditing.
Yes, madam, please
Yes.
tell us.
Good afternoon, sir. Sir, actually, our point was that the minimum average turnover should be 1 crore of last 5 years. Even they have submitted turnover for last 3 years. If the average is 1 crore, they are eligible.
They are eligible.
Yes, because the average should be 1 crore, sir. Our major point was the minimum average turnover of should be 1 crore of last 5 years. Even they have submitted turnover 4 years, the average was more than 1 crore, sir. So that was the point, sir. If you can see, sir.
Page 47.
So that's why they were eligible, sir. And
So therefore, you say.
sir, and one more thing,
No,
sir.
no, let us assume, yeah, wait, just 1 minute.
Sir.
A total calculation of this,
Yes.
of the 4 years they have submitted,
Yes. That was calculated.
is calculated, then also it is 1 crore.
Yes.
Let us calculate, Mr. Bonik, this is 2 crores, 2 crores, 2 crores, 2 crores. So this is 8 crores for 5 years. So therefore they have 160. So therefore you have put 160.
Right. Sir, there is
What
one.
I am on, my lord,
if supposedly it's in page 47 for a moment, how
Then
they
response comes.
let me put it my way, Milord. If
There is
I
no-
take for 5 years, it's an average of 5 years, I have to divide by 5.
Yes, we have divided it by
No,
five.
I mean,
But they have divided by
No,
five,
no,
that is why I'm saying.
I'm on that requirement of me submitting. Thereafter, they're computing. If I have not submitted, I fail. I must submit by page 47. I must do my part. Then correctness of their evaluation comes. If I have not given, I have not given. The requirement is 17, 18, 18, 19, 19, 20, 20, 21, 21, 22. And they say minimum average turnover of rupees 1 crore in last 5 years, and they specify the 5 years. I must mandatorily meet that. I don't have a wishful thinking and choice not to give or to give, even if I earn in crores. If I don't give, it's scenario A. If I give, it's scenario B. Now I can address how they compute, but they have not given. If they have not given, they have not given, Milord. They are taking a stand that whatever financial computations are there, this would suffice the average of 1 crore. I say, with all humility, perhaps the bidder does not have an option to give or not to give.
Mr. Boni, I'm absolutely with you. But can't help it because of the Galaxy judgment wherein it says, the Supreme Court says that I should defer my decision to that of the tendering authority.
Sir,
Well,
there is.
So far as the tendering authority takes a call, it is their call. So far as the conditions are there, they cannot way down from the condition. The conditions are mandatory. The conditions.
It is their understanding.
No, they do not understand differently, Milord.
Mr. Boni, it is their understanding. The understanding of them is we require that for the last 5 years they should have minimum one. Yes, I think you are right. Absolutely. When they are mentioning for 5 years, they have to give this 5 years. They are mentioning 5 years you one should. I also with you. But the moment their understanding is being
Would my lord be pleased if I would pray that this comes by an affidavit on record?
Huh?
This comes tomorrow by way of an affidavit, or not tomorrow, maybe Monday, by way of an affidavit. This statement of theirs, at least it's on record then, how they process the matter. Because these documents we have only now, and by way of submission it's coming up, madam.
Ma'am wants to mention something. Sir, there's a point that we have floated the tender in 2022 May. So they were unable to submit the present 2021 and 22 balance sheet for that reason. So that's why they submitted the 2016 and 16 and 17 balance sheet, and which we did not accept it. And after that also, if they would not have.
What you are saying, just put it on an affidavit, file it tomorrow. We are taking it on Thursday. We'll finish it off.
Your Lordship, if you can have this matter on Monday, Thursday, I'm already on a part heard on Thursday.
Fantastic. Your presence is dispensed with.
Lordship,
You be present.
if Lordship can have it on.
No, Thursday, this matter goes finishes. Has to finish. I have given so much of time.
Lordship on Monday, Lordship, please allow, Lordship, it's a humble request on Monday, Lordship.
You have this document, you have filed it how?
Lordship, we have just submitted it here, we'll file it, Lordship.
Okay, not necessary.
Yes.
I heard Mr.
Lordship, Monday,
Bonik,
please.
heard Mr. S. Bonik, the learned counsel, appearing on behalf of the petitioner in both petition, and Ms. P.
Barua, Lordship.
P. Barua, the learned counsel, appearing on behalf of the, what is the department?
Assam Tourism, Your Lordship. Assam Tourism. And
Appears on behalf of the respondent numbers
2-4, Your Lordship.
3, 4. Good stuff. Mr. R.S. Mishra appears for respondent number 5, and you are appearing? None appears for respondent number 6. You appear for 1, 2. Respondent number 1, no.
3-4.
Madam, you does appears for respondent number 1. Good stuff.
And Prismatic has never entered here in
During the course of the hearing, day, Ms. P. Barua, appearing on behalf of the respondent number 2 to 4, have placed before this court the broadsheet oblique technical evaluation report as per clause 17.2 of the bidding document, a copy of which was also furnished to Mr. S. Bonig, the learned counsel appearing on behalf of the petitioner. While hearing the matter come, a question arose as to whether the respondent number 5 and 6 can be said to be technically eligible in terms with clause 3 Roman 5 of the bid document. This aspect arose in view of the fact that from a perusal of the broadsheet oblique technical evaluation report, it appears that insofar as the respondent number 5 and 6, the turnover of only 4 years was taken. Be that as it may, 4 years was taken. That is from 2017-18 to 2020-21. This court, during the course of the hearing, Miss Madam, your name you give. So and so appears on
Tina Mitra.
Huh?
Tina Mitra.
She's who?
She is a member of the evaluating committee.
So-and-so,
From
was the
Assam.
member of the evaluating committee was present during the course of the hearing. It was mentioned by her during the course of this court upon inquiry made to her. It was submitted that the respondent number 5 and 6 did not submit the financial, did not submit the financial reports for the year 2021-22. However, they duly submitted 5 years from 2016-17 to 2020-21. She further submitted that the technical evaluation committee, taking into consideration that 2016-17 could not be taken into account, disregarded the said turnover for that, disregarded the turnover for that period. However, it was seen that even taking 4 years, that is from 2017 to 2020-21, the average of the respondent number 5 and 6 is more than 1 crore. For the last 5 years. It is seen from the affidavit so filed that this aspect is not reflected. List this matter on
Monday, your lordship.
no Monday business.
Monday, your lordship. Lordship, I'll be in a very big difficulty, lordship. Monday.
Madam, there will be a delay. Okay, on 5th of August 2025. Full stop. An affidavit be brought on record on behalf of the respondents number 2 to 4, clarifying the said aspect of the matter as could be seen from the broadsheet oblique the technical evaluation committee. The affidavit be filed by 1st of August 2025.
March.
List recording. Interim order shall continue till the next.
Applies.
Nothing much would happen also with that right now. We have not been able to finalize it there.
Madam, you could have finalized this Friday. It's because of the difficulty shown by you, it is getting delayed.
Much of
For hearing item 13.
What is this?
This is against an award passed by the Labour Court on 23/2018, whereby the respondents have been directed to be reinstated as casual workers and
By the Brahmaputra board.
by the Brahmaputra Board, Lordship. The award, Lordship, will find,
What is the award says?
the award starts at page 28, Lordship, and the operative portion, Lordship, will find at page 42.
Reinstate the workmen involved in reference in the capacity of casual workers on same wages as applicable to them at the time their disengagement. Such reinstatement shall be done by the management within 60 days from the date of receipt of the award. 50,000 each to all a month involved in the reference within 90 days from the. Okay, then
Now, Lordship, the the respondents were working as casual laborers under the Brahmaputra board earlier. Then thereafter a central government policy had come where, by virtue of which, the laborers were to be kept, if required, to be employed through the contractors. And from 2001, these people were working from 2001, and since 2005, they were under a contractor and we were making payments to the contractor. There was a requisition month to month, we will be requiring this many laborers, and the contractor was supplying the laborers. Now, these respondents, they were placed in a Pagladia subdivision of the dam was supposed to be constructed there. And ultimately what has happened,
they were under the employment of the contractor.
Our claim is they were under the employment of the contractor. Now, this dam did not materialize because the state government could not give the land. And ultimately in 2013, we had to hand over whatever was given to us. Some portion of the land was given to us. We had to hand it over back to the government, and these people, they were workless. There was nothing to do because they were there only to look after the assets that were created in the meantime. That is ward and watch. So basically looking after the assets, keeping them intact. And since there was no work, we discarded with the laborers. We did not need any services furthermore. Pursuant to that, these people went to the CAT because in the year to the CAT.
CAG.
CAT.
Okay.
Central, yes. Because in 1993, there was a policy decision of the government of India that any person who was in the employment, casual laborers who were in the employment of the government of India organizations for 1 year or more on that day, 1993, their services should be brought under temporary status.
Or regular.
Temporary status.
Temporary status.
Yes. Now, since these people were in employment from 2001, they did not fulfill that criteria. And ultimately, the OA was dismissed. It came back. Then a writ petition was filed before this honorable court. And in the writ petition, two issues were framed.
Where is that order?
Writ petition order, Lordship, is not annexed, but the issues I've mentioned here. At page 16. At page 16 of the writ petition.
Page
16 of the writ petition.
Yes.
Whether the petitioners are in the employment,
Where, page 15 of the.
16, 6. Two issues were framed. And
Ah.
whether the petitioners are in the employment of the respondent board, and if so, from which date and what status, temporary or other one. In case it is held,
So this court. Hey, industrial. Make a reference to the central government industrial tribunal to decide the following dispute which exists between the petitioner and the petitioners are in which state and in what capacity. If in case it is held that the petitioner were
but if I may,
it
Lordship,
is being passed by the division bench.
Lordship. Now, if I may, Lordship will kindly look at section 10A.
Where any industrial dispute exists or is apprehended and the employer and the employee agree to refer the dispute to arbitration, they may at any time before the dispute has been referred under section 10 by written agreement refer the dispute to arbitration, and reference shall be such person or persons including the presiding officer of the labor court of the tribunal as the arbitrator, where an arbitration refer the dispute to arbitration.
So that is what I was trying to point out.
When arbitration agreement provide for reference to the one. So then the question of making a reference, because that is why where an industrial has been referred to arbitration. So the power which have been exercised by the division bench, this is by the division bench.
Perhaps that is the section.
The order has been passed by the, I think, because when it went from OM, from CAT,
From CAT,
before the division bench.
It normally goes before the division
The
bench.
division bench order apparently appears to be wrong. Because you, by way of a judicial order, you cannot confer a jurisdiction upon any authority.
But the question is, we have not raised any objection at that. We have not raised any objection at the relevant point of time.
No, understood, but it cannot go to the industrial tribunal.
That is, it has gone
You
now. There is an
cannot
award.
confer a jurisdiction upon the industrial tribunal. Because the conference of the jurisdiction is by the act, and it is only given to the state government under section 10. And if the section 10, the state government does not do so, then a writ can be issued only to the extent of directing the state government or the central government, as the case may be, to take a consideration as to whether a reference can be made, or they are to move the court under section, this particular section of section 10(3).
That has been made in this case.
Huh?
That has been made in this case.
In this
Yes,
case?
yes, I appeared before the division bench. Honorable Justice Sapre was the judge on that, right? And I raised this point. Then he suggested one thing, all right, you make a representation before the central government for adjudication. And this court itself has framed the issues. And it was thereafter we
Here the appropriate government has given the reference.
Yes, appropriate government.
Why you are referring to that? Because here, if you see the award, the appropriate government has sent the present reference with the schedule mentioned, whether petitioners are in employment of the, and if so, what is the hell? Then what is wrong? You have not read the properly.
That should be done.
You are referring to something which has no relevance. That order has no relevance. Because there is already a reference being made
Yes.
under section 10.
Lordship.
In terms of judgment passed by this honorable High Court.
No, maybe or not. We are not concerned. We are that order being passed by the High Court is wrong.
High Court simply framed their issues.
No, the
You
High
can-
Court would not have referred to anything to the central government. What the High Court could have done, is asking you to submit a representation.
Yes, that has been done. That is what,
must have been done, and the central government may have made a reference.
that is what
This
is
the
done.
reference.
Yes.
We are only concerned with the reference.
Lordship.
We prepared a representation by the central government and central government referred this matter.
Because 10A could not have come into.
No,
Now what
So-
is it?
Now, the learned labor court, the tribunal, after taking the evidences of the workmen witnesses, came to the finding which I may take your lordship to, page 41, paragraph 28. Because the evidences that were adduced were all on identical lines. From the evidence adduced in this matter, it is clear that the workmen were originally engaged as casual workers directly by the management, and subsequently from August 2005, they were engaged through labor contractors. It is also clear that even as contract laborers, the same set of workmen continued to work. This very fact categorically indicates that the engagement of the workers subsequently through labor contractors was merely a paper arrangement. Page 41.
it must be done.
The natural consequence of this would be that the workmen are held as casual workers directly under the employment of the principal employer, that is the Brahmaputra board. It is therefore held that at the time of their disengagement, the workmen were casual workers under the board. The management side could not even prima facie prove that the work done by the concerned workmen was not of perennial nature.
Mr. Dasgupta, tell me one thing. They were initially, as per the casual workers, they have worked for 1 year with the Brahmaputra board. But from the report, it appears that they have taken up their services under the contractor.
Yes, no, there's a paper arrangement, nothing else.
No, paper arrangement or whatever may be, whether any payment was made directly by the board to you. No. It must have been paid to the contractor must have paid it. Once a person concerned may have a right to get, he would have been considered to be a workman if he had worked for 240 days. There's no quarrel with that proposition. But the quarrel with this, the problem which appears out here is once he has left the job and is under the contractor, can you say that he can still claim his right which was there at that point of time and work for 5 or 7 years under the contractor?
Yes, that can be done.
How?
Whether
a right which was there for 1 year, that was not, he has given up. Because this has a far-reaching consequence. Just for example, in a particular establishment, a person is a workman, casual employee for 240 days. Thereupon, he joins some other employment, continues there for 10 years or 5 years, and again says that, okay, now reinstate me and put me out here. This is the case because I have a right to continue. Because of that, I was there in a casual employee at one point of time. This is the proposition.
now whether he is in the industrial adjudication blood, this is a very common case. A person may generally may be called as contract labor, but in fact he is the employee of the principal employer, and this contractor is nothing but a paper arrangement. It's smoke screen. So we have to lead the way.
Any judgment in
that? Yes, sir. The hundreds of judgments are there.
Show me
right now, Constitutional Bench 2001 7 SSC page 1, Steel Authority of India. There is a Constitutional Bench judgment.
Let us see that.
I thought the judgment is the hundreds of judgment are given. 2001 7 SCC page 1 probably. Yes, this guy, Haryana, it doesn't. Am I wrong, Miller? 2001 7 SCC page 1.
What is the name?
Steel Authority of India. National. No, 2007 1 7 SSC page 1, yes. Hashan Bhai is also one of the Haryana State Electricity Board versus by
Versus
Haryana State Hassan Bhai one and this is
that is 2007 1 SCC.
2007 1 SCC.
2001
No, 2001 7 SCC, no? 2001 7 SCC page 1.
Authority versus National Union Waterfront Workers.
Steel Authority versus National Union Waterfront Workers. Paragraph 126 probably. I'm sorry, Miller, I have to brought this. Okay. I'll just put that. Only thing is whether it is a paper arrangement or not. What the flag of 126?
Yeah, internet to recovery.
আমার written argument কোথায় হতো?
Paragraph
126 probably. Another judgment is Miller.
No, one thing will do.
99 TSCC.
Wait, let me find out.
601.
61.
One 125 by
120.
The upshot of the above discussion is that before the determination of question whether central government is you are referring to.
Yes, yes.
Which paragraph you're referring to?
120.
Mr. Dasgupta, are you just submitting from your memory? You don't have it. So means both of you are not prepared.
No, no, so far these.
There is stay continuing. There is stay.
No, they have been reinstated now.
All these persons are working now.
They're working now.
Then what is there?
Nothing is there. All of them are still working.
If they have been reinstated, what is there to challenge? You have acted upon their word.
They have been reinstated post filing of the case.
Yes.
Then what remains? But this is an issue where you didn't get a stay.
No, no, there was. And
They are also getting the salary.
at the minimum.
Minimum wage, they are only
at the
getting
minimum
minimum
wages.
wage as a daily wage.
That is the only scope I have. In time stay, prayer for stay will be considered. Till then it may remain suspended. What is this type of? What is your case then? You have a case out there. In my opinion, it is a very difficult thing. But the proposition what Mr. Dasgupta is saying out here, very difficult for me to accept. Because once you are now under another person as a contractor, you go to the contractor and join somebody else. It's permissible.
That
They are
my-
all same
my-
establishment.
I was intending to make submissions on two for Lordship. First is Lordship. They are now the employees of the contractor. We have not made any direct payment to the workmen. Any payment made is through the authorized contractor. And secondly, Lordship, once this project has been discarded, we are not in requirement of workmen. Once this Pagladia Dam project, it's a Pagladia Dam project, which was supposed to be done. Now that has been discarded. We are not in requirement of manpower. So why are we required to keep them? We are not required to keep them.
The answer is that you then go for retrenchment.
No, data partner, this is a case of between a data partner, we have been transferred to Nolbari division.
So the question is whether they could have the management submitted to the work for which the concern was initially engaged as casual layer was purely a temporary nature, and when the work ceased to exist there could not have been by way of continue the engagement. Management side has paid for answering the reference to the negative. The evidence deduced is clear that the workman was originally engaged as casual by the management, and subsequently from Iman they were engaged through labor contractors. Also clear that even as a contract laborer, the same set of workmen continue to work. This very fact clearly indicates the engagement of the workmen through labor contractors was merely a paper arrangement. A natural consequence of this would be that the workmen are to be held at. It's a very difficult thing proposition. Unless he has not referred to any judgment also.
No.
You have also not referred. You have not also referred to that judgment. So therefore I will hold it. You could not. They cannot be they cannot be considered it to be a paper transaction. What is the basis on which you are holding it to be a paper transaction? A person now he is under the employment of somebody else. You might be. And what are the terms and conditions on which you have appointed some contractor? You must have said that you have to abide by the contract.
No, just a minute, sorry, sorry. Your Lordship, come to page 31. Paragraph 4. That is their own contention, they are casual employees.
No, there is no quarrel. They were casual employees.
No, present also they are considering
No.
casual employee for the purpose of conferment of the temporary status, a committee was constituted. And this committee examined all the aspects and they recommended that as they are casual employee, they should be conferred with the temporary status.
I would just come in between. Now, Lordship, the consideration which was made at that point of time.
That is
Now,
the
whether
full
the-
case.
No, so
Oh,
let me
sorry.
finish. Whether it was a right consideration, because that consideration was to the effect that whether they could be considered under the 1993 scheme. Apparently, if I may take your lordship to the 1993 scheme.
No, Mr. Architect Chaudhary, the question arises when a person concerned have left the employment of the person of the establishment.
That could not have been done.
And thereupon God himself engaged as a contract laborer. Can he again claim any right from the previous owner?
No.
Established.
No.
There's no judgment. In my opinion, that is wrong. That cannot be so.
One time I will bring the judge, all the judges.
You are not prepared. Well, please, no judgment. And I don't see this judgment has any relevance to that. This judgment which you are referring to.
He does not paper and that.
No. Contract labor, whether it's carried out.
Constitutional bench.
Then whether the industry is carried out by virtue of conferment of power of commissioner and not whether you are particularly the labor welfare.
126. Not 150.
Paragraph 71. Paragraph 71 of the statement.
Paragraph 71.
71. That's it. Contract labor at 670 as defined in clause 3 of subsection. A workman shall be deemed to be employed as a contract laborer in or in connection with the work of an establishment where he is hired or in connection with the said work by or to a contractor with or without the knowledge of the principal employer. By definition, the term contract laborer is a species of workman. A workman shall be so deemed when he is hired in or in connection with the work of an establishment by or to a contractor with or without the knowledge of a principal employer. A workman may be hired in an establishment by the principal employer or by his agent with or without the knowledge of the principal employer, or in connection with the work of an establishment by the principal employer to a contractor or by a contractor with or without the knowledge of the principal employer. Where the workman is hired in or in connection with the work of an establishment by the principal employer through a contractor, he merely acts as an agent, so there will be a master and servant relationship between the principal employer and the workman. But where the workman is hired in or in connection with the work of an establishment by the contractor, either because he has undertaken to produce a given result for the establishment, or because he supplies the workman for any work of the establishment, a question may arise whether the contractor is a mere camouflage, as in Hussein Bhai and so and so.
Yes.
And if the answer is in the affirmative, the workman will be in fact an employee of the principal employee. But if the answer is in the negative, the workman will be a contract laborer. It may be noticed that the term work contractor is defined in so and so. So this is what is in 71, then 89. And like 87 paragraph. Now turning the provisions of the, you have that?
Yes, I'm looking at that.
Read 87. Here the question is the terms of the contract entered into between you and the contractor is the relevant document.
Lordship.
This can be, if we may say so, the eloquence of the CLRA Act is not by spelling out the consequence of evolution of the contract labor system discerned in the light of various reports on the influence and object. It appears that to be that the Parliament intended to create a bar on engaging contract labor in the establishment covered by the prohibition by an employee, principal employer, so as to leave no option with him except to employ the workman or regular employees directly. Section 10 is intended to work as a permanent solution to the problem rather than provide a contract labor abolition act. is intended to work as a permanent solution to the problem rather than provide.
It's What's up? What we need 99 TSC 601. TSC. TSC 601 para 20. TSC.
No, if there is a bar under section 10 to appoint somebody as a contract laborer, there's a bar.
Under contract level regulation vision.
Yes.
No, no.
Notwithstanding
Section-
anything
section
contained
10
in
is
that,
meant-
the appropriate government may, after consultation with the central government or as the case may be decided, prohibit by notification in the official gazette employment of contract laborer in any process, operation or other work in any establishment. Before issuance of notification, is there any notification to that effect by the central?
So far section 10 is concerned, Miller. If there is in an establishment, if there is an engagement of contract level, genuine contract level, then also central government may prohibit engagement of the contract level. For that purpose, they are to consider 4 factors that is indicated in section 10(1) A, B, C, D. And while issuing the notification, they are to consult with the advisory board. That is the provision contained in section 10.
Deemed to be employed as a contract laborer in or
Now, in an establishment, there may be a contract. Line to jail. Whether he's a genuine contract laborer or not, that should be examined. Simply because the person concerned, he is working since 1999. All on a sudden, government says, no, we shall not engage contract labor. We shall not engage casual labor. So all the person concerned who are working as a casual labor, they are called as contract labor. And one contractor has been imposed. That is the factual, yes. Whether that is only a paper arrangement or not. Good, sir. Paragraph number 20.
But there may be some of the reasons as to why no specific provision is made for automatic absorption of contract in the In the light of the other, we are unable to perceive in section 10 any implicit requirement of an automatic adoption of a contract labor by the principal employee in the establishment concerned on issuance of a notification by the secretary. So, as per section 10, as per the Contract Labor Regulation and Abolition Act 1970, there can be a ban or abolition.
Yes.
Subsequent, subject to issuance of a notification by the central government or the state government concerned.
Yes, under section 10.
Then, once there is a ban, then those persons who were working as contract labor gets a right to be reinstated or absorbed by the principal employer.
No, that was the case. Yes, your lordship is absolutely correct. That was the case at one point of time. In the year 1997, the Supreme Court passed an order. That is Air India Statute 1997. When the contract labor is abolished, then the person concerned who are working as a contract labor, they will be considered as the principal employee of the principal employer. Now that view has been negated by this judgment. What is with
Here, therefore, it says, in the light of the above discussions, we are unable to perceive in section 10 any implicit requirement of automatic absorption of contract labor by the principal employer.
Yes.
In the establishment concerned on issuance of a notification by the appropriate government under section 10
That is a one
meeting so and so.
Yes. Earlier judgment has been overruled.
But tell me one thing. Is there a notification issued in this case?
No.
Then how does the Contract Labor Regulation and Abolition Act 1970 comes into the picture?
This is the judgment, my lord. When what happened in this case, notification was issued. Now, after issuance of the notification, Bombay High Court delivered a judgment that all these persons should be considered as the employee of the principal employer. That judgment was asserted in the Supreme Court. Supreme Court upheld this judgment. Now, subsequently, the judgment rendered by the Supreme Court has been referred to the Constitutional Bench. That is the case we are going. Now, Supreme Court, in this case, ratio of this case is that whether a person concerned is a contract labor or not, that has to be assessed through by assessing the actual situation. Whether this contractor is a real contractor or a contractor by making a paper arrangement, whether it is a camouflage, whether it is a smoke screen. If it is found that it is he is not a real contractor, but an arranged contractor, then and only then he can be considered as the employee of the principal employer. That is the ratio of this judgment. Merely because the notification was issued, all the person concerned will not be automatically the employee of the principal employer. That was held by the Supreme Court in the year 1997. And that judgment has been overruled by this judgment, Constitutional Bench judgment. The only thing has to be considered.
That is the case of Hussain Bhai.
Yeah, that is earlier cases. First case is Hussain Bhai. Hussain Bhai, there are several cases were rendered. Now, ultimately, this is a particular judgment in the year 1997, Air India Statutory Corporation case. Here it is once notification is issued. That judgment has been overruled by this constitutional judgment. Now, the basic issue is that a person concerned is working as a contract labor. He says that though I am called as a contract labor, but in fact I am an employee of the principal employer. In order to deprive me to have the real wages that are entitled by a regular employee, you have called me as a contract labor by making some artificial arrangement. Whether this arrangement is a paper arrangement.
But whether the paper arrangement was before the labor court. Whether the paper arrangement, you are saying to be a paper arrangement. The fact that these people from 2005 was working under the contractor is not in doubt. Now they have said that we are not going to carry out that particular work any further, which led to these people losing their jobs. Now the question is whether it is a paper arrangement or anything. Was it at all looked into?
Yes.
Where is that? But the Labour Court did not look into anything to that effect.
Yes, yes, my lord.
Kindly see paragraph 28 of the judgment. It did not say anything. Page 41.
16 workers adduced their evidence.
Understood, but using the evidence, they have stated what? Then look here. I was employed up till 2005 with the Brahmaputra board. From 2005, we have been working out like this. Now they have closed this particular thing, and therefore now we are employed under that. We are actually workmen under them. Now the court comes to a finding at paragraph number 28 that it is a paper transaction. But whether it is a paper transaction or not, isn't it required that there should have been an adjudication? How? Finally come to paragraph 28, page 41. Yes, Mr. Deto, you read it. Me and Mr. Dasgupta shall hear you.
Being the younger one, I will take the privilege. From the evidence adduced in this matter, it is clear that the workmen were originally engaged as casual workers directly by the management. So page 41. And subsequently from August 2005, they were engaged through labor contractors. It is also clear that even as contract laborers, the same set of workmen continued to work. This very fact categorically indicates that the engagement of the...
Now, this aspect, it is also clear that even as contract labor, the same set of workmen continued to work. So that remains. This very fact categorically indicates that the engagement of the workmen subsequently through contract labor was a mere paper arrangement. The natural consequences of this would be that the workmen are to be held as casual employees directly under the employment of the principal employer. That is the Brahmaputra board. It is therefore held at the time of their disengagement, the workmen were casually under the board. The management side could not even prima facie prove the work done by the concerned workmen was not of perennial nature. The workmen were admittedly working for Viman continuously for more than 12 years till they were disengaged. Were you working for 12 years?
Yes.
Lordship will
If it is 12 years, then you come back to 1993.
No, Lordship will kindly come to page 31. Page 31.
It appears the
Paragraph
doesn't look so.
Paragraph
Because
4.
when was the judgment they delivered? 2018.
Yes.
So therefore they were doing.
They were there since 2001.
Were discontinued from the engagement by Brahmaputra board by an order. Did you disengage?
Yes, they disengaged.
Huh?
No.
You disengaged the workmen.
Lordship will kindly
Where is
come.
that document? 24.3.
That document is not here, but if I may,
I know how you people.
Lordship to Annexure 2 at page 43.
Page 40.
43. And page 45.
The contractor was one Bijoy Goswami.
এর আগে যে petition, পুরানো petition।
Where is your disengagement letter?
Page 45, Lordship.
Then why didn't you write it to the contractor?
Yes. It's not to the contractor.
So it appears to be a paper transaction.
That was not brought in evidence, Lordship.
How many are there? 26.
Lordship, 25.
24.
Oh.
One had died, no?
One has expired.
One person expired.
24, I think. Earlier 26 is there, but here somewhere I've seen it. So your termination letter, as well as this communication, these two communications, 15 May 2013 and 29th April 2013.
It's not to the contractor, Lordship.
Huh?
It's not to the contractor. It's not to the contractor, Lordship.
Now this is, no, kindly see the second part of that. So therefore appears to be just a paper transaction. Although the appointment made to Bijoy Goswami, if you have insisted on day, could have been definitely not properly conducted, not properly advised.
কি লিখিছে মই বুজি পোৱা নাই।
So this if you have maintained this stand.
That's
Here,
what
what
I've
did
been-
you say? As far as practicable, local personnel will have to be engaged. So how he has done it, he has engaged, you should have kept it with a Chinese wall.
That ought to be have been brought in the evidence, Lordship.
We'll dismiss it. Heard Mr. R.K. Dev Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. A. Das Gupta, the learned counsel, who appears on behalf of the respondent numbers.
All right.
1 to 25. Somebody died.
Yes, Lord. Our wife, his wife is number one died, Lord. Generally, his wife's name is Rumia Begum. He number
No, they-
50,000 rupees was awarded to each. Instead of back wage, every workman was awarded with a
50,000.
50,000.
That has not been paid.
That has not been paid. And this amount
Appears on behalf of respondent numbers 1 to 25. The present, the extraordinary jurisdiction of the court have been invoked, challenging the award dated (23) 2018, passed by the Central Government Industrial Tribunal cum Labour Court, Guwahati, in reference case number 02/2015, whereby the learned industrial tribunal directed to reinstate the respondents herein in the capacity of casual workers on the same wages as was applicable to them at the time of their disengagement, and further directed the petitioner hearing, the petitioner number 2 herein to pay the lump sum compensation of rupees 50,000 each to all the workmen involved in the reference within 90 days from the date of receipt of the award in lieu of back wages. It is relevant to take note of that this award dated 23 2018 was notified. Was it notified?
Yes.
Was notified. And thereupon, the instant petition was filed on 1/10/2018.
With the C1, C2 order.
The record further reveals that by an order dated 16/11/2018, notice was issued. But there was no notice was issued. And the impugned award was suspended till the next date. Subsequent thereto, there is no order by which the interim order was extended.
Miller filed an application under section 17B, and that application was allowed. And thereafter, Millard, all these workmen were reinstated. Instead of paying us last wages, these persons were reinstated.
During the pendency of the proceeding, the petitioner, the respondents herein filed an interlocutory application being ISC number 431/2019 under section claiming their dues in terms with section 17B of the Industrial Disputes Act 1947, for short the Act of 1947. This court allowed the said application and directed the management to pay the full wages last drawn by the respondents herein, inclusive of any maintenance allowance as provided under the rules, if any. And further, the petitioner number 2 was granted the liberty to deploy the respondents in any project under the petitioner number 2.
No.
It further appears that this court, by an order dated 4/8/2021, directed the respondent number 2 to continue to pay the wages to the respondents in terms with the order dated 14/9/2019 with effect from 16/11/2020 till date, till 4/8/2021. Another important aspect which requires to be taken note of, that in pursuance to the order passed in IAC 431/2019, the respondents herein, except the respondent number 1, have been reinstated and they have been paid the same due, the minimum wages. As regards the respondent number 1, the question of reinstatement did not arise, taking into account that the respondent number 1, the husband of the respondent number 1, expired. In the backdrop of the above, let this court now take into consideration whether this is a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution, exercise of its tertiary jurisdiction under Article 2 to 6 of the Constitution. Take a seat. The materials on record show that the respondents herein were employed as master role casual workers in the establishment of the petitioner number 2 sometime in the year 2001 and 2002, and they continue to render service till July 2005. It further appears that these respondents, the private respondents, thereupon were engaged as contract laborers, were engaged as were engaged by a contractor, namely, was engaged by a contractor. In the Pagladia Dam project, which the petitioner number two, the petitioners herein were taking steps for setting up. It may not be out of place out here to mention that the government of Assam was supposed to hand over land for the purpose of that, for the purpose of the development of the Pagladia Dam project. Only 956 hectares of land was handed over, and these workmen and the private respondent herein were engaged to watch and ward the 956 hectares of land which was handed over by the state of Assam. It happened so that the state of Assam failed to hand over the balanced land of 6529 hectares in spite of a considerable period, in spite of the 6529 hectares. This resulted in abandoning the project, the Pagladia Dam project. It is very pertinent to take note of that on 15 May 2013, the chief engineer one of the petitioner number 2 board had written a letter to the Secretary, Government of Assam Water Resource Department, wherein it was mentioned that there was a unanimous decision taken in the 56th meeting of the petitioner number 2 on 22/3/2013, whereby on account of the inability of the BTC to provide the balanced land of 6529 hectares, the project would be abandoned, and all the members were in agreement to issue a notice for disengagement of the personnel engaged for watch and ward of 956 hectares of land provided by the state government to the Brahmaputra board.
Before disengagement, all these workmen were transferred to Nalbari subdivision. That is paragraph 26.
The said communication, the contents of the said communication being relevant is reproduced here in under page 43. It is further also relevant to take note of that on the basis of the said decision, the secretary of the petitioner number 2 on 29/4/2013 directed the superintending engineer, Nalbari Circle, Brahmaputra Board, to disengage the 26 personnel engaged for watch and ward of the 956 hectares of land handed over by the government of Assam to the Brahmaputra Board for development of Bagladia Dam project with effect from 1st of June 2013. Pusto. The said communication, the contents of the said communication is reproduced here in under page 45. Poropa number to signature, it was a secretary signature. Pursuant thereto, the petitioners were the respondents herein were disengaged, which resulted in the respondents approaching the Central Administrative Tribunal, claiming benefits, claiming non-consideration of benefits in terms with claiming appropriate directions for consideration of the case of the respondents in terms with the casual laborers bracket grant of temporary status and regularization scheme of the Government of India 1993. This application so filed before the Central Administrative Tribunal registered as OA number 143/2013 was rejected, which resulted in filing of a writ petition before this court, which was registered and numbered as WPC number 1958/2014, which resulted in filing of 2 writ proceedings, being WPC number 1958/2014 and WPC number 1490/2014. The learned division bench of this court, by an order dated 5/5/2014, issued appropriate directions issued certain directions to the appropriate government to make a reference and in consequence thereof, the central government, the appropriate government, that is the central government, no?
Yes, Government of India.
That is the central government had made a reference on, do you know the date? And consequent therefore,
Terms of reference mentioned in the page 29.
had made a reference on 10th of June 2025, 15. The order so passed, the terms of reference so made is as herein under. Itu page 29 bold junto ase. It is noticed that the learned Central Government Industrial Tribunal, after recording evidence arrived at an opinion that the engagement of the respondents through the contractor was merely a paper transaction, and for all purposes, the respondents continued to remain the employees of the petitioner number 2, and accordingly directed passing off, passed the award, directing the petitioner number 2 to reinstate the workmen in the capacity of casual employees on the same wages as applicable to them at the time of their disengagement, and further awarding an amount of rupees 50,000 to each workman in lieu of back wages. Next. Mr. R.K. Dev Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that the question of that the learned labor industrial tribunal had erred in law as well as on facts, had committed an error in exercise of jurisdiction in coming to a conclusion that it was a paper transaction insofar as the disengagement of the petitioner and the respondents from the petitioner number 2 board and the engagement of the respondents by the contractor. He further submitted that as the respondents were only engaged for watch and ward of the Pagladea dam project, and as the said dam project had been abandoned, the learned labor court ought not to have passed appropriate direction, issued the award. Mr. A. Dasgupta, the learned senior counsel appearing on behalf of the respondent, submitted that the order of disengagement clearly speaks that there was directions issued by the petitioner number 2 to the superintendent of petitioner number 2 for disengagement of the respondents herein, meaning thereby that for all intents and purposes, the petitioner petitioner number 2 was the principal employer and the respondents were the workmen, and the employment and the contract entered into with the contractor was merely a camouflage to Yes. In that regard, the learned senior counsel referred to the Constitution bench of the Supreme Court in the case of Steel Authority of India Limited and others versus National Union Waterfront Workers and others, reported in 2001 7 SCC 1, and more particularly to paragraph number 71 of the said judgment. In the backdrop of the above materials of record and in the backdrop of the above submissions, comma, this court have also perused the records which were called for from the which were called from the learned industrial tribunal. The materials on record, Pustak. Amongst the various documents which were exhibited, it appears that exhibit number 6 was the report of the committee for grant of temporary status to casual workers under the Brahmaputra Board. This report is dated. What is the date of the report? Any date? Mr. R.K. Dave Chaudhary, I am helping you out or you are helping me out?
No, Lordship, I'm trying to find out that.
What is the date of the report?
4/8/2010.
4/8?
2010.
10.
Lordship will find that at page 39.
4/8/2010.
He also
Report
admitted the
dated
committee.
4/8/2010. Sure?
Yes, Lordship. it's
4/8/2010. Very. The list of casual workers working under the respondent number 2, petitioner number 2, have been duly mentioned. It is seen that from the said report, the respondent's name appears in the list of casual workers working under the respondent number 2, petitioner number 2, who were recommended for conferring temporary status. Names are there, na? Names are there. Oh, yeah. Please. Further to that, it is also seen that the respondents herein, the names of the respondents were shown in the said list as engaged as casual laborer, casual workers in the Pagladia Dam Division Roman 1, Roman 2, is further seen that a decision was taken in the 52nd meeting of the Brahmaputra board to be held at, which was held on 22nd of November 2010. Certificate of judgment. Wherein this court further takes note of that the learned industrial tribunal at this stage, this court finds it very pertinent to take note of the judgment of the Constitution Bench in the case of Steel Authority of India Limited Supra. Wherein the Supreme Court wherein the Constitution Bench observed that a question arises, observe that depending on the answer, as to whether the employment of the workman was closed or not. Depending upon an adjudication as to whether the employment of a workman was a camouflage or was under the direct employment of the contractor, it can be ascertained as to whether the employee, the workman, was as to whether there was a master-servant relationship between the principal and employee and the workman. This court finds it very pertinent to take note of paragraph 71 of the sage judgment, which is reproduced here in under. The learned tribunal, the learned industrial tribunal, on the basis of the evidence, had come to an opinion that it was merely a paper transaction, paper arrangement by which the respondents herein, who were all along under the employment of the petitioner number 2, were being engaged through a contractor. And this aspect and this finding of fact is arrived at on the basis of evidence which included the order dated 29/4/2013, whereby the petitioner number 2 board had disengaged the respondents. This court is of the opinion it is very pertinent to observe that this court is not sitting as an appellate court. And the exercise of the jurisdiction is limited to see as regards the decision-making process. At this stage, this court finds relevant to take note of the judgment of the Supreme Court in the case of Central Research Center, and more particularly paragraph number 50 and 51, which deals with as to how the certiorari jurisdiction of this court is required to be exercised. The same paragraphs being pertinent is reproduced hereunder. In the backdrop of the above, if this court duly takes note of the materials on record, and more particularly, materials on record, the findings arrived at by the learned labor industrial tribunal, and the disengagement of the petitioner, of the respondents, on the basis of the as would be seen from the communication dated 15/5/2013 and 29/4/2013, which have been already quoted here in above, it is the opinion of this court that this is not a fit case for exercising the certiorari jurisdiction, inasmuch as there appears to be no error in exercise of jurisdiction. Consequently, this court finds no ground to interfere to the impugn award dated so-and-so, for which the writ petition stands dismissed. The records so called for be returned back to the learned court, learned tribunal below.
So far the backwages are concerned, that has not been paid.
50,000. You know what to do. Why should I say? If they don't pay it, go there.
Again, 43C2.
Put them behind bars. Oh, long time. 4:45 is over. Meeting.
Item
Yes.
16 and 17, my lord. 16 and 17.
I thought that I'll be rising early and I thought that it is 4:10 or something. In fact, the problem which is happening is in my earlier court, my watch was there. Now I don't have the watch. I don't see this side.
The lunch break, these are the display. This is front side, this front side.
The notice is no longer there.
Huh?
The notice